High five. If they are huggable, please hug them. Yes, but the personal space, eh?
I'm Stuart from Warwick University.
Can I also request that if you can reshuffle ourselves, if you've got somebody you've chatted with for the last 1 hour, you've already established, eh? So karibuni sana to our legal aid clinic. This is one of our most prestigious events on campus. And it's prestigious because of the caliber of people that we have. They're called councils. Eh? So if you are council, say aye. Okay, the rest I assume you're not councils.
They need to be cancelled.
And they need to be cancelled, eh? And that is why we are having this. So, karibuni sana. Allow me to recognize the presence of a couple of guests and partners that are with us here today. But allow me to start with the data privacy and governance students. Can you be upstanding? Tupige makofi. And they were introduced that they are from University of Nairobi. So I intentionally avoided introducing them that students from University of Nairobi. So tupige makofi tena, asanteni sana, karibuni. Thank you very much. We also have the LAC advocates. Tupige makofi. Those are our partners, the LAC advocates, asante sana. Hata wanakaa advocates, eh? The council, I'm an advocate. I do not want, when you're dealing with the council, I'm a council, I'm an advocate. I'm a both. Both advocates. Asanteni sana. Karibu sana. We have Data Privacy and Governance Society. Tupige makofi. Hey. Hii story ya data protection, eh? Sasa, simpige makofi tena. And by the way, because these data people are here, we do not want to be sued. And we have ensured, that again, if you sign consent, I hope all of us have been given consent forms to sign. They are out there. If you do not like your pictures to be taken, we have taken care of that. If you would like your pictures to be taken, we have taken care of that as well. But we are also saying that the reason why these pictures are being taken is not for advertising. It's for purposes of transmitting the information that, that you are here, eh? And that this event happened. So how else do we say the event happened? We do not want, to say the event happened and it happened at USIU and there were people. We were not having chairs. So we are not advertising, we are just informing. And we are also informing on how important it is to have this legal aid clinic. Because all of us need some of these services. So I'm just mentioning that, again, the pictures being taken is not for advertising. Should we convert as a result of that? Just know that they just like that USIU usually organize things like this one. But we are not saying come because we did organize a legal aid event. Allow me also to recognize the presence of the Delivery Quality Legal Services Unit. Do you have something like that? That is very serious. Then?
That's just their byline.
Oh, that is the byline.
They are called
Haya, so umesikia. Can you just, we want to, and the senior council is here. If the team can stand, we want to appreciate them. Tuwapige makofi. It's a full house, eh? And we are looking forward to learning. Asanteni sana, karibuni USIU. Asante sana. Again, internally, we have our members of management board. If you can be upstanding, we just want to appreciate you. I can see the Director of Legal Services, I can see, tuwapige makofi. So we also have our faculty. So faculty USIU-Africa, uko wapi? Si niliwaona yawa. These are professors. Hey? So the faculty, so some of them, we have staff of USIU. Sasa staff mmekaa tu, ni sawa tu. Tupige makofi. Asante sana. And by the way, we have come with questions. Councils, we have come with questions. And we like it small, we like it tight, we like it deep. That is why, we have come with questions. So be ready for our questions. Our students, akuna USIU students? Tupige makofi, USIU students. And by the way, we have staff that are also doubling as students. So probably they stood when we called the staff and they do not want to be repeat. So asante sana, but also recognizing and appreciating this is a collaborative effort of different divisions within the institutions, and we just want to appreciate those divisions for taking part, and supporting, this important event. So allow me to welcome our DVC for academics, Professor Amos Njuguna, to welcome us to USIU-Africa on behalf of our Vice Chancellor, Professor Mwenda Ntarangwi. Karibu, tupige makofi.
Thank you. Our guests today are members of the university community. Ladies and gentlemen, good morning.
Good morning.
I'm in front of the law, so Helen, you'll help me. You'll signal to me. Now that one, you should say it the other way to mean what you want to say. But on behalf of the Vice Chancellor, Professor Mwenda Ntarangwi, I wish to welcome you officially to USIU-Africa. USIU-Africa is a friendly campus, very inclusive campus, and we love all that come. We respect everyone, regardless of the different diversity. We thrive in diversity. Actually, we are in the mood for the culture week that's happening next week. We are already in that mood where we appreciate everyone. So if you are here as a visitor, just tap whoever is next to you, and I am sure they will be as friendly as you can in welcoming you to our great campus. And I mean that, just tap them. Today's event is one of those that has become an annual ritual. Is it a ritual or ceremony? It's become an annual activity that members of the university community keep looking forward to. I'm sure quite a number are online, and along the way, many people join depending on which sessions they really want to participate in. So we really don't take the time that our partners have taken for granted. We appreciate that. I can see one of the members of our university council, Ms. Patricia Kiwanuka. Again, we don't take, let's give her, again, we don't take your time for granted. We are really privileged to have you here, share these moments with us. Being a university that's oriented towards problem solving, legal aspects cannot be ignored. You will want to do a lot of things. You will want to solve your IT issues. You will want to solve your financial issues. You will want to solve issues in pharmacy and health sciences, but you cannot ignore the legal aspects and the connections that they do have. And that's why, as a community, we feel very privileged, not only to establish this relationship, but to keep it burning. So with that, I wish us well. Let us participate in all these activities, and we are eager to learn. Forgive us if we ask some very, very basic questions, or we demonstrate a bit of fear in this. Forgive us, but we are willing to learn. And again, thank you everyone for showing up, and let's make this day fun, a day of fun and learning. So with that, Mr. MC, thank you. And again, on behalf of our Vice Chancellor, Phil at USIU. And of course, find something to do with USIU after today. I always say, if you are not working with USIU on something, I don't know who you are working with.
Tumpigie DVC makofi. You know. By the way, it's only in USIU. It's only in USIU. Find out more, but it's only in USIU. Yes, we are the most diverse institution, diverse. 43 countries in Africa, more than 70 across the world, all 47 counties in Kenya. So very national and very international. You know, in terms of inclusivity, we are also the most inclusive. In fact, I encourage us. We are in a building which hosts our disability resource center on the ground floor. You know, we take students with all forms of disability, hidden, learning, physical, visual, hearing, they are all here. So we are very inclusive university. And we urge you, if you meet a partner out there that is looking for a university that can take care of their children or the neighborhood, please refer them, you know, to USIU-Africa. You know, so asanteni sana. Allow me to recognize, we also have special guests from University of Warwick. I got that correctly? If you can just be standing, we just want to appreciate you. We are very international. I just said we are international. You know, and just quick introduction, not just sitting, quick introduction. You know, the beauty with MC is that the MC can break some protocols. You know, this was not part of the program. You know, Sunday. Just quick introductions, just the name. You know, and yes.
I'm Professor Anne Stewart from the Law School at the University of Warwick. You probably will never have heard of this. If you know about Coventry Football Club, well, we're near there in the Midlands. And we're here to visit your lovely university. Thank you very much for the invitation, and to do a presentation a bit later, but also to celebrate, if that's the right word, Warwick's engagement with African scholarship over 60 years, because our university is 60 years old this or next year, around now, and we've always been very engaged in African scholarship. So thank you very much for having us here, and this is my colleague.
Hi everyone, I'm Dr. Jeremy Okonjo. I'm an assistant professor of law at the University of Warwick. Anne Stewart is my colleague. And I also happen to be a wakili, so it's very nice to be together with before I betrayed you and entered academia, I used to be part of you. So very nice to be here, and we look forward to interactions. And thank you for inviting us to USIU.
Thank you very much, Jeremy. My name is Caroline Rashingwa. I'm sure you can tell I have an accent. So I'm a daughter of the continent and originally from the DRC, so just neighbor of Kenya, of course. And I'm the Africa lead for Warwick University. But on top of that, I'm also the chair of Africa at WILA. WILA is the organization that oversees the interests of all the universities in the UK, so I'm the chair for Africa. So engage with the UK government on matters pertaining to education. And talking about diversity, Warwick is really diverse as well. So we have students from over 150 nationalities. And yeah, Yes. So thank you very much, and we'll be here downstairs. If you want to engage with us, engage with our academics, but also engage with me, potentially if you're considering maybe doing a PhD or anything. So I'll be around as well, so you can engage with us. Thank you very much, and we're really happy to be here.
Thank you very much. A round of applause. Thank you very much. Tupige makofi tena. And by the way, that was intentional. Very intentional. You know, USIU, we are keen on transition. You know, and we transition our students through 3 pathways: further studies, entrepreneurship, and dignified work. You know, so we are glad that we have transitions partners. Tuwapige makofi tena. Tuwapige makofi. So we are keen and we are looking forward. So at this point, ladies and gentlemen, this event is being streamed live, just for information. So we, you know, and you can also take some selfies, be in Snapchat, be in Facebook, you know, just say you are here. It's important to mention that you are here, you know. And I just wanted to recognize another Wakili who is in faculty, you know. Prof, I see you there. Can you please wave? That is our professor in criminal justice program, right? Yeah. We just wave. Asante sana. There are fellow professors here that you can engage with. They are looking for engagement.
She's part of us as well. Terry is part of us.
Oh, thank you.
She's doing her PhD with us.
Thank you very much. So at this point, let's put our hands together, ladies and gentlemen, to encourage Director of Legal Services, you know, to take us through the rest of the program, but also to let us know why we are here. Asante sana, Wakili. Wakili ni kama wengi, na kama ni moja tunaita aje? Okil ama mkili, ngeli ya mwa. Kuna ngeli ya mwa, lakini wote ni wakili. Asante sana, karibu director.
Thank you, Ines. Good morning. Should I say the way they say in church? Good morning again. Okay, something that I've just gotten on SMS. We have a dedicated Wi-Fi. So, come on in, Yvonne. So nice to see you. Name is Legal Clinic. Password is Wakili Quick 1. Okay? All right. Welcome to the 2025 edition of the USIU Legal Aid Clinic. This year's clinic, Patricia.
Me.
Who's talking?
Not me.
Oh, okay. This year's clinic marks 8 years since we embarked on a series of activities aimed at demystifying legal issues and is in furtherance of our objectives under the current strategic plan relating to community engagement and excellence in service. Curating this clinic was no mean feat. We spent days poring over material, identifying panelists that would bring both legal and practical skills to bear, brainstorming internally and externally on topical legal issues that would not only be of interest and significance, but that would strike the right chord with the target audience. Legal aid is anchored in the Constitution of Kenya, and it is critical that the higher education sector plays its role in ensuring that citizens are not only informed, but also have access to justice. It's indeed delightful to see USIU continue to play its role in that regard. Over the next 2 hours or so, you will hear from a group of experts on issues ranging from legal rights in the digital age, AI and IP in everyday life, as well as workplace, academic and sexual harassment, and gender dynamics in career progression. We have partnered and leveraged on our networks to bring legal aid closer home at no cost to yourselves. So be sure to join us for the afternoon session 2, when our team of experts retires to designated pods to address any legal issues you may have in a private, secure space. The objective is to bring you to an understanding of the law in its various facets, how it affects you as an individual, and ultimately, how your actions as an individual affect the university and the society at large. At the end of the day, we hope we will have played a role in shaping the next generation of innovators, thinkers, and leaders. So sit back, open your mind, and prepare to be educated, capital E, inspired, capital I, and in some instances, entertained, capital E. I would like to close with the following quote attributed to Carl Sagan, and that has been the motivating factor for these clinics. Who are we, if not measured by our impact on others? That's who we are. We are not who we say we are. We are not who we want to be. We are the sum of the influence and impact that we have in our lives and on others. I am grateful that I have raised and nurtured a generation of lawyers that assisted in making these clinics a success over the past 8 years. So allow me to acknowledge my current and former pupils. If you're here, please stand. Legal counsel who just walked in, Yvonne Moram Wendy, and of course, principal legal. Josephine, stand up. Sophie, Effie. Yeah, thank you. This would not be possible without you. Thank you to our partners also, and to the university leadership for giving us this space and the resources to play our part in this noble initiative. Asante. Over to you.
Tupige wakili makofi. Na mnakaa mmechoka, hebu tusimame. Let's stand. Hey! Hey, hii sasa lazima tukatch mosquito. Nani anajua kukatch mosquito? Nani anajua kukatch mosquito? Mosquito. Mosquito. Hey, you know, that is the beauty. Mosquito. Do ile about look for mosquito. Mosquito. Where are you finding the mosquito? Find mosquito. Mosquito, prepare where, you know, and then I'll try to tap mosquito. Have you tapped it? Yes. No, it has escaped. So let's start again. Mosquito. Look around, look for this mosquito. You know, if you found it, then try to. Thank you, you may be seated. By the way, we were doing that for our director legal. That is Helen. We were doing that for her. You know. So, asante sana. Ladies and gentlemen, at this point, let's put our hands to welcome, you know, the chair of our finance committee of the University Council, you know, Ms. Patricia Kiwanuka. Tupige makofi. Asante sana. And you need to declare kama wewe ni wakili. Asante sana.
You can hear from the title, I am not the mosquito. I am definitely not a lawyer, so I have to start with certain things. I wore these shoes because of Helen. She insisted, the instructions I was given last night were, dress smart casual. I said, smart casual, I can wear jeans. No, dress official. So this is me attempting to be official. But it's a pleasure to be here. And I have to say, my journey here was even more entertaining. I came by boda. At wow. So, Wakwili, a quick one. If my boda between Kileleshwa and here had a problem, for those from Warwick, that's like 15 kilometers on a bike behind a guy I don't know, flying and my eyes doing whoo. That's the expression, right? So Wakili, a quick one. Is there a risk? Mukiongea hii story tafadhali. Please, answer that question for me, right? James, that is for you when you stand here. So a very good morning to everyone. I know you may have seen my bio or may not have seen my bio, but I'm a business owner. Fortunately, I'm a woman. For the men around, I'm sorry. I'm an entrepreneur, but I'm also on council. So when I'm sharing or talking, I will be using my experiences from that part. More importantly, for those who know me, I have never been too serious in life, and I'm also a psychologist. So if you have any problems after I talk, please come and see me. I will understand. But it's a true privilege to be here and to represent the council. And Helen and the team, we appreciate the legal work you do. And for the rest of the management board, we really appreciate you being here, because it shows me a cohesion around the team and what you do. So, with that said, my dad passed away a few years ago, and he said, the 3 people you must be most honest with are your doctor, your lawyer, and your priest. And I always wondered, what does that mean? Does that mean I'm not honest to myself? So I just kind of want you to think, call yourself to a small meeting for 2 seconds and ask, did you lie to yourself this morning that you were thin? Or you were taller? Because your priest or your lawyer will see it immediately and will call it out. Isn't that true? So I want you to look at your neighbor. Look at your neighbor. Just find someone next to you and just look at them. And tell them, I like your nose. Did you just lie to them? But for me, that's where the ability to be able to enjoy life. And the lawyers around my life have taught me 2 things. Life is serious, but also, it's never that serious. If you've gone to the law courts in Kenya, it does take a while to go through a legal process. Life is never that serious, so don't take it personally, is what I have learned from the lawyers. More importantly, I've also learned, you don't talk to lawyers because you're in trouble. Now, a lot of us avoid. In fact, when you're told to talk to a lawyer or a regulator or something like that, you fear them, right? So I'm sitting here and I'm laughing because I know Madame Lumasi there was, okay, Eunice. Can I use Eunice? Yeah. You see, she actually mediated a case. It didn't go very far, and I'll give that story later. But on the screen, I thought she was, yeah, that explains, right? But she was fair. She was very fair in the case. But if I had met her on the street, if someone had told me, walk up to her and just say hi, I'd probably have gotten very scared. When I walked in, I smiled at James, and he smiled back. And I actually smiled because I thought he was faculty. The next thing I was told, he's a lawyer, and my next reaction was, do I have a case with him? So it's never that serious. So don't talk to a lawyer just because you're in a crisis. For me, that's the first introduction I have. A couple of 4 things I want to talk about. The first one is about my reflection around justice and empowerment. A few years ago, I had a very personal crisis. My house girl came and said to me, her girl who was about 9 at the time, was pregnant. Now, you've already gotten the I'm here in my house, minding my business, and you tell me your 9-year-old is pregnant. I don't know whether to go to feed her, whether to cry, whether to beat you. I mean, there's a whole range of emotions. And I called my lawyer and I said, what do I do with this case? And he said to me, just sit back. 1, send her to me. It's not your problem. It's beyond you. So you cannot even go into counseling for this person. You're too involved. Get behind it. And he took the case pro bono. The case ended. The little girl has visited me. She has her daughter. And all of them are fine. And the case ended correctly, as in the culprit was caught. Now, I have another case which I've also alluded to, where here we are, a big company asks me for money. I lend them money, and they choose not to pay it back. We've tried mediation, we've tried everything. It's now like 6 or 7 years. It's still in the court. My head is clear. I am going away with their land, even if it takes me another 25 years. Again, that's a personal experience. So 1 case proceeded to conclusion. 1 case is still proceeding. But remember what I said at the beginning? Take it. And you remember this thing saying, Wakili, a quick one. A quick one is 7 years later. Let's keep that conversation. Second one. Legal is supposed to support growth. So both for me as an entrepreneur, as an individual, as a business owner, as a director, legal for me is an enabler. So for the students here who are doing law, for those who are her pupils, and everyone else who's practicing law, I'd like you to come into the meeting with a view of your enabling us, not with a view to call me out on the problems. Because at times I don't see your perspective. Remember, I don't know law. I may have a lot of degrees, but I am not a lawyer. And for that, I'm clear. So a number of examples I have, for example, in insurance. We turn down a lot of claims in insurance. Is that true, lawyers? Yeah. In other markets, you'd have, what do you call them, ambulance chasing lawyers? Those exist. We don't have them quite as prevalently in Kenya. Now, for me, every time I see a law case coming through when I'm sitting as a director in an insurance firm, first I read the small print, you know that very small one? Do you know one of the things, just to educate you as an insurance person, one of the things we don't cover is mountain climbing, and we don't cover hoover boats. Do you know those things you put your children on? The ones that, hey. And bungee jumping. Are you aware? Lawyers, you've not read this thing. If you haven't, please look for that thing. So when you bring me a case and I say no, I refer you to item number 1.021 in small print at the back, right? That's insurance. Why is that? Because every time we get a case from legal, we learn and we improve our paper. But at the same time, we should start asking the question, are some of these things becoming the normal way of life? So for example, people hike on Longonot all the time. Should I cover that case or should I consider it a mountain? That's a question for you guys. So I really appreciate it when legal comes to me from a position of enabling or providing me with guidance to make me better. And so far I can say at USIU, that's the experience I have, even from the finance side. There's definitely an intersection between business, law, and how we operate in society. If the society is not working right, you have more cases, right? And my security also becomes less. Is that true? So that intersection and how the legal system works is very important. When I speak to people internationally, especially within Africa, they believe that the legal system in Kenya is very strong. They're starting from our constitution to how it's been written to how we follow our policies and procedures. However, at the same time, we're also told we're the most corrupt or one of the most corrupt. So the question I always ask is, where is this intersection? Is it that the process takes too long, that people feel they can get away with it, or what happens? But from a business point of view, if you just search recent cases, I'm from the financial market. If you look at the AIG crisis, you look at Parmalat, you look at Enron, and all these cases, where did they end up? In courts. Significant fines. Recently in Nigeria, Shell had an issue where they poured oil on the ocean, right? The fine from that spill. Now, what frustrates me the most is those risks had been raised before, not just by internal audit, not just by their lawyer. And the business did what? Ignored it. So lawyers, position yourself in a way that tells me the value you bring to my business. Now, as I'm saying this, I'm looking at Anne Mutia here because I worked with her. She was a lawyer when I was heading a business. And I always remember that conversation that said, tell me the risk before it happens. Don't come to me after the risk and tell me, now let's go to court. Do you understand? Become a business enabler. Finally, as I close this out, I'm in an academic institution. I hope one day, 1 week, I have personal, what are they called? Feelings. I thought I would come to Warwick to do actuarial science. It never happened. But I still finished. I never became an actuary, but life, you can see, has not turned out too bad. So PhD may happen. But being here with academia also tells me certain things. There's always opportunity for learning. And continuous learning must be intentional. So whether you're talking to Amos after this and asking him about what programs do we have for executives, whether you're thinking like me, should I be doing a PhD? I am not sure I want to commit that time. But there's always continuous learning. Once you graduate, how you position yourself for the next level pivots you to the success that you have. So me personally, I've gone through the whole cycle. I've gone through investments, I've gone through actuarial, I've gone through management and governance. And here you can hear I'm saying I'm now back at the beginning as a psychologist. And more recently, as an intern at Gertrude's Hospital. That tells you learning is always a continuous process. So with that said, I would like to encourage you that as we do this, as you go to the legal workshop, as you get access to these facilities, use them, listen, ask the questions, and the other thing Helen always tells me, it's never the wrong question to your lawyer. Just, if it's in your head and you're thinking it, just ask it. So now, kindly tell your neighbor, did you lie about their nose, or is it true? There are a few who are still lying. And with that said, Ines, I'll hand back to you and say thank you very much and welcome to USIU, and we are very glad that you're here.
We can do better, we can do better. In fact, I expect University of Warwick to be giving standing ovations because they already have a PhD candidate there. But Professor Njuguna is also watching keenly. You know, you might just consider, you know, tumpige makofi tena. You know, I'm sitting here listening to Patricia and I'm asking if we are to invite, you know, Patricia on now the investment side. Now we were doing, now this is the law. Now, when she's now wearing her professional hat, you know, especially on the business side, but thank you, that is very inspirational. And I think we are picking something. The young lawyers, the young advocates, you've learned, eh? What is important is, how is your work enabling, as opposed to be a potential roadblocks? You know, some of us see lawyers as, when they ask those difficult questions, are you helping me, or are you making it tougher for me? You know, and they're telling you, wait until it happens. When it happens, then they will tell you, we warned you, now look at the cost of the result and effect of not listening. So we can draw some lessons, but what is important, are we enabling? Are we enabling? You know, ladies and gentlemen, and of course with apologies, we were supposed to be having, you know, Honorable Justice Isaac Lenaola, but he has an emergency. But he had prepared a fantastic presentation for us. And that presentation is going to be delivered by one James Okeyo. Now, we can be upstanding for the justice. You know? that is called a standing ovation as the justice is coming to deliver the keynote address. Kiongozi karibu, kiongozi. You see now even the way he's walking, kiongozi karibu, kiongozi karibu. Asante sana.
Good morning, you may be seated. By the powers conferred upon me and all protocols observed, the judge would have been delighted to join you this morning for the second edition of the USIU-Africa Legal Clinic. He commends USIU-Africa's partners for offering their legal services to the USIU-Africa student body and their participation in today's discussions on legal rights in the digital age, including the nature of artificial intelligence, intellectual property, and financial services, as well as on workplace, academic, and sexual harassment. You may now allow me to use I. Thank you for agreeing with me. I also recognize the Data Protection and Governance Society's key contribution to today's conversation. USIU Africa's emerging practices of hosting an annual legal aid clinic is respectable, providing youth with access to the expertise of legal practitioners free of charge and to have their legal questions and concerns addressed is key to establishing and maintaining a law-abiding society. Furthermore, this initiative highlights the importance of engaging all, regardless of their academic background, in key conversations regarding their legal rights and obligations. The importance of such dialogue cannot be overstated, since ignorance of the law is not an excuse. Knowing and understanding the laws that govern our personal and professional interactions strengthens one's ability to protect his or her rights. Additionally, While some may assume that conversations on law are limited to legal professionals and students, and perhaps individuals in fields such as business, criminal justice, and international relations, the law actually plays a key role in all professions. Before addressing the laws that govern interactions in professional settings, I must first emphasize the importance of understanding the core rights and freedoms guaranteed by the Constitution. Chapter 4 of the Constitution of Kenya 2010 is known as the Bill of Rights. It highlights inalienable rights, including freedom from torture and cruel, inhuman, or degrading treatment or punishment, and slavery or servitude, as we may call it, as well as the right to a fair trial and the right to an order of habeas corpus. The latter referring to a legal process that strives to prevent unlawful detention by requiring the presentation of a detained person before the court. The right to life, dignity, privacy, and freedom from discrimination are also found within the Bill of Rights, and I charge you all to learn the rights and freedoms guaranteed to you under the Constitution of Kenya. Furthermore, the Bill of Rights also plays a key role in guiding the formulation of numerous statutes, including those that address professional conduct. Article 23(1) and 2 of the Sexual Offences Act 2006 states that sexual harassment is any unwelcome sexual advances or requests made by an individual in a position of authority or holding a public office towards another individual whose employment, career, work, educational performance, and or access to a public service is dependent on his or her submission to or rejection of the said advances or requests. For those with entrepreneurial ambitions, take note of your legal responsibility to prevent sexual harassment in the workplace as you build your businesses. Article 6, Subarticle 2 of the Employment Act 2007 obliges those who employ 20 or more individuals to issue a policy statement on sexual harassment, following consultations with those employees or their representatives. Moreover, Article 6(1)(a) of the Employment Act 2007 again defines sexual harassment as the direct or indirect request towards an employee from his or her employer, the employer's representative, or a colleague for sexual intercourse, sexual contact, or any other form of sexual activity implicitly or explicitly promising a preferential treatment in employment and or threatens detrimental treatment in employment or the present or future employee status or employment status of that employee. Additionally, Article 6(1)(b) through to D expands the definition of sexual harassment to include the use of written or spoken language, visual material, and or physical behavior of a sexual nature, with the latter of the aforementioned three forms of sexual harassment serving to directly or indirectly subject the employee to behavior that is unwelcome or offensive, so that the employee, and that by its nature, has a detrimental effect on that employee's employment, job performance, or job satisfaction. To all the creatives, innovators, and scientists, your knowledge of laws governing intellectual property is key if you seek to protect your original work as you advance in your careers. I strongly advise you all to peruse statutes such as the Industrial Property Act 2001, the Copyright Act also of 2001, and the Trademarks Act Chapter 5 or 6 of the laws of Kenya to gain a better understanding of how to secure your intellectual property rights. I therefore strongly urge you all to make the most of this year's Legal Aid Clinic by tapping into the wealth of knowledge and expertise offered by the legal professionals present here today and currently at your disposal. Furthermore, I expect all present here today to acquaint themselves with the laws of Kenya, starting with the Bill of Rights within the Constitution and extending to the Sexual Offences Act, the Employment Act, and the various statutes governing intellectual property, all of which can be found online and downloaded for free. Whether a citizen of Kenya or not, knowledge of Kenyan law is of a paramount importance for all of those who reside within the country, as in Kenya, we say ignorance of the law is not an excuse. And with those very few remarks, I wish you all a productive and enlightening session. Thank you, and for those who thought it was me, this is none other than my good friend, old friend, the Honorable Mr. Justice Isaac Lenaola, CBS, Supreme Court Judge, Vice President, Special Residual Court for Sierra Leone, and President of the International Association of Refugee and Migration Judges. I am Ri. Thank you.
Pige makofi tena. Huyu ni Supreme Court Judge, the apex, the apex. Tupige makofi tena. Asante sana. And now the learning begins. The learning begins. This is where now you take your pen, you take your notes, and you prepare your brains. Do you need to prepare the brains, or the brains are ready? The brains are ready. You know, and this session is going to be moderated by our very own Director Legal Services. Let's give a round of applause. And allow me to invite the following on stage. You know, the Mtoga Gaturu advocates, part of the panel. Please take your seats. Can we have LAC advocates? And can we have the Data Protection and Governance Society? Yes. And we need to ensure we are as balanced as possible. Director, this microphone is yours. We'll get you as many microphones as you need. Asante sana. Tupige makofi tena. Asante sana.
Okay, so I need someone to move this, because the panel discussion is normally, you know, we're seated. Thank you. Okay, we had curated this in 3 parts, but I'll be randomly just speaking questions from each section. And we'll start with the lawyers were introduced, isn't it? Each one of you, Cindy? Oh, okay. So this is Francis.
Good morning, everyone. My name is Francis Munyango. I'm from the Data Privacy and Governance Society of Kenya, DPGSK. Happy to see the university chapter from the University of Nairobi here. Happy to be here as well.
Good morning, everyone. My name is Anne Mutie. I'm also representing the Data Governance Society, and I'm also an advocate.
Good morning. How are you? My name is Anthony. I am an advocate. I'm a practicing advocate, and I am here courtesy of the Data Governance and Privacy Society of Kenya. Looking forward to very impactful and interesting engagements. Thank you.
Good morning again. My name is James Okeo. I'm an advocate, and I practice in the firm of Muthoga Gaturu and Company Advocates. We are happy to be here, and we'll be looking forward to engage.
Yeah, happy to see our friends of USIU, and we hope you'll now be also friends of USIU. We have a long-standing relationship with Muthoga Gaturu Advocates.
Good morning, everyone. Good morning. Good morning. My name is Cynthia Cyprus. I'm an associate at Mudoga Gaturu, also a certified professional mediator. Happy to be here.
Good morning, everybody. My name is Lydia Mayeka. I'm an associate at Mudoga Gaturu and Company Advocates, as well as a certified professional mediator. I'm happy to be here, and I look forward to engaging with you all.
Good morning, everyone. My name is Peter Kimoshu, an advocate of the High Court of Kenya, practicing at Mudoga Gaturu and Company Advocates, alongside my colleagues here. I'm happy to be here, looking forward to interacting with you, and looking forward for some enticing questions. Thank you.
And to another friend of USIU.
Absolutely. Good morning, everyone. My name is Lumala Sunes. I'm an advocate. I run a farm. One of my partner is here, Paulette Acheng. Please, Paulette, say hi. Paulette is a guru in matters conveyancing, property related law. And she's also a counselor. And she's, what else? She's also doing corporate company secretarial and has a passion for children's matters of late. So you see, the continuous learning. And she's a fantastic friend. We were together as pupils. We are still together. Members of LAC advocates present, please just stand and wave. Yeah, part of our team is there, and we are really ready for you. I look forward to a fun time. I'm a trial lawyer. That means I try matters in court, but I'm also an ADR practitioner. I do arbitration, both domestic and international, and mediation as well. Of course, you heard my name being mentioned. I'll not go into further details. Thank you very much. I'm happy to be here.
Thank you. So we'll get started. The first panel discussion, and I will switch it up as we go along, is on legal rights in the digital age. Mawakilia, you know, this space has opened up, and there are a lot of issues that have come with that. So I'll be looking mostly to see, because some of the questions that came out have to do with data protection, and the concern is what are the most critical data protection measures individuals and organizations should implement. Any takers for that?
So, good morning once again. As a data protection practitioner, the responsibility to protect and preserve your data starts with you, all right? In terms of the amount of data that you put out there, and ensuring that you only disclose information that is necessary. And by the time you are disclosing your information, you do understand why is this information being collected, for what purpose, and you know, any measures that that organization has put in place to be able to protect and preserve your data. That's on the individual level. At an organizational level, number one, let's use USIU as an example. You must first understand the various data points or the various avenues through which you collect personal data. So that exercise is known as data mapping. After understanding that, then you must also confirm whether you are collecting personal data excessively. Are you collecting information that you don't actually need? All right? The second step is you must put up data protection compliance framework. All right? And this is comprised of various things. Number one, you must start with registration with the Office of the Data Commissioner as a data controller or as a data processor, or both, because there are instances where you will be either or both. Then you must put in place policies and procedures that guide your staff members on how to handle personal data. Then finally, you must undertake tailored training for your staff members so that they know how to deal with data privacy issues. And we've seen organizations in the country being penalized for not having trained their staff members, you know? So you must train your people adequately and maintain those records that on such and such a date, we took our staff members through this kind of training. Finally, you may not, those of us who have been in compliance space, we understand that you can never be 100% compliant. And that's why even in your risk appetite statement, you have some room for breaches here and there, you know. Now, you must have a very elaborate incident management process, such that if an individual's personal data is mishandled or mismanaged, how do you respond to that incident? And if possible, handle these matters and don't let them escalate, because you're putting up your image on the line. Those would be my initial reactions, Helen, and I would yield back to you. Thank you.
Now, unless somebody has something to add or he has exhaustively covered that, I'll do the Q&A after, because a question has just popped up from what you've said. And it's a concern that I would say that I also have as a director legal. When you have a policy, bring your own device policy. What sort of extra safeguards should you as an organization take? Because we realize in the transition, when employees leave, they leave with your information, and we've seen cases where employers have been sued because an employee left with customers' data on their device, either deliberately or unwittingly. And even if it was not their device, they just left customer data and then go out there and I'll use the example of insurance. They go out there and contact the customer. So while we find this as, efficient ways of managing how we do our work, there are these risks that come with bringing your own device. So what extra safeguards should an organization put in place besides having a proper handover process?
What I would say is, at the end of the day, the Data Protection Act is structured to promote the interests of the individuals who entrust you with your data, with their data. And so the organization must be proactive in how it decides to collect and how it decides to protect data. Now, when you put in place something like bring your own device, you have to go back and look at your obligations as an organization, because the fact that I have allowed you to bring this device does not take away from the fact that the Act says I need to put in place privacy by design and by default. I need to achieve that, meaning I need to have proper policies and proper procedures. So for you as an organization, and what I have seen with clients who bring your own device policy, it is usually driven by organizational needs. Maybe it's too expensive to have everybody be bought for a device within your organization, or it could be you need to promote work from home policies and kind of things. What you need to do in addition to that policy is think through the technical safeguards that you can include in your ecosystem, your computing ecosystem or your digital ecosystem. Two, in as much as possible, secure the data in those devices that actually belongs to your customers or is personal data that would bring a breach upon you as an organization. And so technology has evolved to the point where now we have things like remote wiping solutions. So that as much as I give you a device, I still have control over the applications that you have put there that are mine, that have personal data, or that could be able to be breached if they are in the hands of the wrong people. You could also have a virtual private network. Think about how you can really secure the network beyond just having the person have a device. But at the end of the day, the word suggests data controller. Somebody must be in control. So if you have just given an employee and written a policy, but there is no real control, then you are again exposing yourself to liability. So it's really about how you structure the policy, what safeguards you put, but how your safeguards and your policies are speaking the same language. Because what we have seen as organizations are being taken to the commissioner is many people are writing policies, but they don't speak the same language as what is happening on the ground. Vitu kwa ground is different. And so that is what you are encouraged to do. Look at the technically, how can I enforce such a policy?
I've been given the microphone, so I'll say something. Just to add on what you said, data protection has transformed over the years, from 2014 to 2016 when the GDPR was being enacted. They had not anticipated COVID in 2020. And COVID, what did COVID introduce the world to? Remote working, BCPs, business continuity plans, where now you have an entire organization still running, but people are not meeting physically. And now that increases the amount of work that is done digitally outside the premise. Within the premise, it's easier to control. You have desktops, you have devices within you have your network, which you have even denied other people access. But now outside there, probably these employees using a shared Wi-Fi somewhere. So as you said, if you're to implement a bring your own device approach, how I'd advise an entity seeking that is to really look for technology that will help you to keep your company assets within those devices. Like, I know organizations where you may access like their Microsoft and you cannot download a single document on your devices, on your personal device. So as long as you're within that application, you cannot download a Word document, a PDF. You can work within that application. Such technologies, of course, will cost cash, but now it's for you to make the call. Should we buy laptops or should we do this? Because also, slowly, because of these issues of data leaks, you find that modern devices no longer even have USB ports because of people putting, they became much more risky than convenient. And now you find that you just enhance the DLP, data loss prevention technologies, so that one justifies why they're sending this kind of information to an outsider. If it's not within their scope, that you have controls in place. Now there's the policy, but now controlled role-based access. Like now, for example, in financial services, you find that if you're not customer-facing, why do you have why you shouldn't be having access to customer data if you're not customer-facing? So, and if at any point you have like data that looks like customer-facing, now you see now this is you as an entity investing in technology that can detect that this person, first of all, does not have access to this database, and then they are sending around information that they should not ideally be sending because they do not have access to this. You're a lawyer and then you're sending Excel sheets with customer information. There's a mismatch there. There's something that is going on that should not be happening, and of course there should be approvals for that. So it's about just having controls that are tailor-made to your organization, keeping in mind that human beings can be mischievous. Of course, you can only do so much. You can only do so much, but you need to do the best that you can.
Then again, I was just quick thinking, as legal minds, you look for loopholes and way to solve whatever situation you find yourself into. So as an organization, what I've seen some organizations practicing currently, at the point of separation with your employees, if they had access to certain kind of data that maybe even trade secrets you wouldn't want going out there, just not excluding customer data, you sign NDAs with these employees. So then they know they are bound to the non-disclosure agreement, where now they cannot go and release this data that came to their possession easily, just like that. Yeah.
Maybe I can just make a contribution. I think for large corporations, it can be expected that it's possible for them to invest in technology. But I think no matter how well you try, sometimes you cannot stop mischievous humans who want to go and start their own businesses from using data they collected from your place to go out there and start calling numbers and sending messages. They, no matter the best, whatever you can, particularly for small individual firms, they'll still do that. So how best do you do that? I think we are challenged to look also at our employment agreements. For example, you've talked about non-disclosure, so that you say, this is where my liability goes. After this, then it's your liability. And we know as trial lawyers in court, you can get a court order to compel Yahoo, Google, whatever, to trace where a message is coming from and actually detect who may have sent it. And you can use that in court. Thank you.
Just out of curiosity, Eunice, besides the office of the ODPC, have you, as an ADR expert, had a situation where you've had to preside over a dispute that involves data?
Yes, and it's a continuous thing. I think right now we have a client, because we all know there's also a right not to be, forgotten. You have a right to be forgotten. Isn't that true? Yes. Because sometimes you do something and it's all of a sudden it's online now. We have a case relating to a GBV violence. It arises out of actually workplace sexual harassment. And the lady, so to speak, went to court, won the case, but all her details are online. So if you go EKLR, whatever, she says it's been difficult for her to get employment because most of our employers, when they're doing searches. Right now, I hope we are all managing what you're posting online, ladies and gentlemen. Yeah, it depends with what you want to be. So you monitor what you post. So employers actually go to your pages, they check, they Google about you. So she says she's having a difficulty getting employment because when they check online, they get afraid this one will take us to court, Somehow, you need to report sexual harassment and violence at workplace, but there appears to be repercussions. So in that instance, it's an issue of, I want to be forgotten online. How do I go about it? So you reach out to the service providers, the law reporting, and the rest, and now we are engaging them to remove amicably all her details relating to her case. Actually use her initials instead of her full name so that people don't get to know who it really is, like in children's matters and in divorce matters. We don't have that in maybe sexual harassment and sexual related offenses, and we're actually thinking of a petition to compel legislative change to ensure that sexual offences related victims have their names removed. So yeah, so we are doing that. I think I can use just that one example.
You've actually preempted a question that was to come up in the panel 3 on workplace, academic and sexual harassment. And when you spoke about petitioning for legislation, it took me back to a decision, I think that was made, was it last year, late last year, where the Court of Appeal, I think it was a 3-judge bench, Kiage, I know, was on that bench. They gave this very interesting decision about how the accused in a sexual harassment incident should cross-examine the complainant. And I don't think anybody has appealed against that decision. And it throws organizations in a quandary. So are you saying in an institution like this, a lecturer or a staff member sexually harasses a student, and I have to subject this student to cross-examination by the lecturer or the staff member? So I'm looking forward to how this petition will go, because I feel like there should be an appeal against this decision from the Court of Appeal. Otherwise, there's a precedent that has been set, and we are finding that people are now moving towards saying, I want to see my alleged accuser, if I'm there, accused, and I want to be able to cross-examine this person. Yet we have a duty to protect the victim. So how you balance out those rights, the rights of the so-called accused and those of the victim.
I don't know whether it's another case of the chicken or the egg. We lawyers have been known to say we would rather 99 guilty people walk free than one innocent person being convicted and rotting in the cells. Why? Because that one innocent person will one day be me. So at some point, the perpetrator remains a suspect or is upgraded to an accused person. At any of those stages, when they're a suspect, they have a fundamental right to confront their accuser. And when you get to court, the best tool that a lawyer uses is cross-examination. So without cross-examination, I think I'll go and become a farmer finally, as I've been training to do. You deny me the right of cross-examination is to test the veracity of the accusations vis-a-vis the facts. So what we need to do, even with the right to be forgotten, is that we could have some of these trials then in camera. A section of it is in camera. Because let's pick something like rape. What the rape victims fear the most is to be raped over again at a police station. There's some cheeky policemen, ati alifanya, ebu just repeat. You have to relate what happened over and over again. If you are a support system for that rape victim, if you ever got raped or something, you don't want to report. You'd rather deal with it in any other way. So there's a very clear balance to be struck. But I think if the judiciary pronounces itself so strongly, they'll scare everybody else to ever report.
Yeah, which you can add to that. Paulette, you were there once when I had the occasion of cross-examining a barely 8-year-old girl. I was defending the accused, who was a 16-year-old boy who was accused of defiling this young girl, and I was representing him. So in court, and it was in camera, I had to cross-examine her. And I had to, because she's young, I had to sit next to her as I'm asking her questions. Of course, at the end of the day, it's an issue of balancing, because you have to balance the rights of the accused, because the accused you know, these are matters where you can also convict someone on only the evidence of the victim. So you also don't want to deny the accused the right to get their day in court, but they can use a representative. It doesn't have to be the person themselves. Like this time I was representing the accused. We got a very lenient term for bond, but the accused disappeared, so he let me down. But
so you see, in our case, that would be a bit difficult to do because one, it's the lecturer or staff member versus the student. Ours is a quasi-judicial process, an administrative hearing that we are taking you through. So we need to find a way to balance that so that we are not having that being cited as a challenge or a technicality when we eventually do send you away and you feel like I'm aggrieved. You did not give me an opportunity to cross-examine my complainant, and I didn't even know who the complainant was, but we know that you know who the victim is. It's just that you have found a lawyer who has found a way to challenge the process. So in sum, what I'm saying is I'm looking forward to this kind of petition where we are looking at how do we protect the victims, because like he said, it will lead to, and it is slowly leading there, to a situation where already as a student or even a staff member, I'm scared of coming forward with my complaint because now I'm like, nothing is going to happen, or I'm going to be exposed to my harasser once again.
Actually, now that you've mentioned it, I've just thought of another case that was also decided last year by Justice Rika in September. He's seen it, so maybe we hope with time and with progression, there are other judicial officers will tend to think that way. But you know how precedences work. The one you cited was from Court of Appeal. This is a lower court. But then he saw it, he's resonating the same way, where he decided that the complainant doesn't have to come to be questioned. It's not as a matter of course that you get to question the person. The complaint can be there unsigned, unnamed, anonymously, and it will still stand as long as the investigations now are taken procedurally.
Yeah, so we use we use that route. We don't expect that there has to be a complainant. We can also take action against you when we get a whistleblower report. But for Eunice, would this be the kind of cases perhaps that would be subjected to ADR and not mediation? Because mediation would be the harasser, the victim, talking directly unless somebody else is talking on behalf of the victim.
I think one of the most important things that can be put in place is a proper complaints handling mechanism in every institution. How is that complaint reported? To whom is the complaint reported? And therefore, after that, what investigatory mechanisms are put in place to get the correct culprit and the correct incidences, you know? So you have to be very meticulous about the complaint handling mechanism and how investigations are done. That way, I think it will be, you get a just outcome. I know there was a document that was prepared. I think it was quite useful. It was a complaints handling mechanism by the Ombudsman Commission on Administrative Justice. It just gives a general framework on how this can be done. You need to be clear about who is receiving the complaints, accept anonymous complaints as well, and different types of hearings depending on the type and the nature of the complaint.
If I may, Helen? Yeah, sure. What we are seeing now is many of these cases are finding their way into data protection. So what you have mentioned about pleadings stating full names of people is actually a case that appeared before the data commissioner last year. when a lawyer retweeted a plaint in which the minor's details were very evident and present. And the complainant was very quick, and they had a case in the High Court. That plaint was in the High Court. So they ran to the data commissioner to say, even as the case is going on, this is an infringement of my privacy because that was a minor's data. And actually the decision that came out there is yes, when we are dealing with minors, even the court pleadings must anonymize because of the constitutional provision that you must promote the best interests of the child in all scenarios. So what I'm finding is litigants are now also looking at what is the data protection angle. So even as you're thinking of your policies, always also remember the right to privacy is a constitutional right. So you have to balance that right with, of course, what you have to do, which is be fair to the whole process and to the person who has been accused and give them the right to be heard. But some of those things like anonymizing and giving as little detail as possible, or exercising what we call progressive disclosure. Disclose at the time, don't give so much at the very beginning, just do it progressively as you go on with your trial process. That then gives you the balance and you ensure you do what he was saying, which is minimize and don't have too much data out at any given time.
Okay, Rachel, you're here, GEP officer, but your DVC is here, so he has noted.
Helen, I had two closing thoughts on that, because we must balance the accused person's right to a fair hearing and the right to a fair administrative action. At the same time, we must also safeguard the rights and interests of the victim. All right? So the first thing, or the starting point, is that at the complaint level, when we have not had both sides, it's still a complaint. We should not be quick to treat the accused person as a convict, right? And that must be in our processes as an organization. Because the worst case scenario would be that, and this will go to, especially if it's an employee, this will go to the employment courts, and we all know how employment courts operate. They are pro-employee, right? And you give the employee low-hanging fruits. It becomes very easy for them to, win cases and get precedents set. So that's the starting point, Helen. And your processes around sexual harassment and how we treat accused persons should have that at the back of your mind. And then we could borrow a leaf from the Witness Protection Act and see what tenets can we borrow and incorporate in our processes to be able to also protect the complainant. All right. So those are two important thoughts that I thought we can consider in enriching our processes.
Thank you. I think we've kind of exhausted that one, so thank you all for your input on that. There was a question about the subtle ways in which individuals sign off their data protection rights unknowingly.
I think Patricia actually mentioned it. Right now it's in the fine print. It's in just how fast you click accept when you get onto a website and you just don't know what you have accepted. How fast you download Tala, Branch, and all those nice mobile lending apps, and you click yes, 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 because you just want the money. and then you don't see fine print, they say they're going to call your grandmother if you do not pay back the loan. So I think, yes, for me, one of those ways is people are not paying attention to the fine print policies, which many times are saving the organizations those claims, because they can say, you know, I used my transparency, and then there'll be other arguments they can go through.
Most of the decisions that you see on the DPC concerning digital lenders, in fact, if you look at the last 3 years, digital lenders were the most cited players in ODPC complaints. That was 2023 and 2022. In 2024, there's a reduction because if you look at, we did as a DPGSK, we did a report on all the decisions that ODPC published in 2024, and for financial services and digital lending, it was at 34%. So there was a reduction because I think most of them learned, but how I put it is that when in the digital world, we have convenience, but convenience comes at the cost of now your information. And sometimes the source of this information is various players. I'm ordering pizza via Glovo, so I'll give Glovo my information. I stay in this place. This is my phone number. Glovo will give it to the pizza guys who will prepare the pizza, and then now the pizza guy will give it to a rider to deliver it to me. These are various players. Now, the challenge that comes in now this convenience is that because we haven't built a culture of privacy, there are certain things that we do that now, in as much as it may be in the fine print in terms of disclosures and the privacy statements that we have, people within the chain of transaction can misuse this information, and they breach the principle of purpose limitation. So the information was for this purpose, for this transaction, but now you are like, have all this information of these people, probably can tell them, I can be their shopper. If you need something from the supermarket, I can be bringing you, because of, after all, I operate between Milema and here. So, and the supermarkets are around here. So that aspect, due to the lack of culture, is where now, in as much as you may sign off your privacy rights, someone somewhere within your team can still mess you up by breaching purpose limitation.
Just an instance that I came across. One lady borrowed money from a mobile lending app.
She borrowed some money from a mobile lending app, and you know they ask you questions, allow access to your phone calls, etc., and your contacts. So for her, she just pressed accept, 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 and then one time when she defaulted, the mobile lending app called her pastor. Her pastor is being told this lady has defaulted, you are a guarantor, and the pastor is not aware of these things. The lady ran to us saying, they are harassing my family, my pastor, my friends, the people I frequently talk to. And when you do a demand to them, and they write back, showing you exactly which clauses in the agreed terms and conditions that you agreed to. So these are things I think we should look at before we press accept, that small box down there. At least read the fine print. How will they use that data? How are they going to handle it before pressing on accept? At least beware.
Maybe also, when we are excited, we tend to just disclose everything. Yes. So now when you get a baby, for example, let's just use that as an example, because it also goes to our personal security and all that. You are so excited, you have a baby, You disclose the baby's images, and you even say that you are at a certain restaurant in Kilimani or Kileleshwa near Patricia's place, you know? And what that means is that because you are being driven by this excitement, or you get a new job and you want to tell everybody we have this party and we are enjoying it at a certain place. So you are selling yourself out, and you are giving information out, too much information out there that may fall in the wrong places and in the wrong hands, and you don't even know what they will do with that information, you know? Last year we saw a lot of data privacy breaches, you know, our leaders, when a section of the country was not happy with leaders and the kind of things that are happening, and we are supporting them. I don't want sitaki kusalimiwa. So what happened is that you would see details of someone's wife, children, where they school, where they live, you know. Because of that, again, excitement and probably even that anger. Sometimes, and maybe counselors can tell us, when you are overexcited, you tend to discontinue reasoning, you know, sometimes. And when you are overly angry or infuriated, again, reasoning tends to take a backseat. So I think at a personal level, and as a data protection practitioner, in as much as we are helping organizations to put robust data compliance frameworks, we're also speaking to individuals. Because at the end of the day, personal data relates to an individual, you and I. If this personal data is misused, we are even putting lives at jeopardy, you know, because we've seen so many cases of violence. You know, sometimes as someone who is aggrieved with, let's say, an example of Patricia, and I know she's attending a party somewhere, you know, again, you don't know what I would do with that information. Yeah. Thank you.
We have interesting dynamics which are asking whether these data protection laws apply when someone is deceased. But what we saw last year was an obituary was put out, and they said where the funeral service was going to be of one of our very learned colleagues, very senior in the profession. And when the funeral service was going on, robbers went to his house and actually wiped clean when the funeral service was up because of the details that were contained in the notice for the obituary. So what he's saying is important, is that you have to be very careful how much you put out yourself. And some of these things, it is a moment of deep grief, what he's saying. Those moments that we can get very unaware are the moments where we are most vulnerable. Either we need money urgently, we are grieving, we are excited. Just take care how much you're releasing, because you can unknowingly now expose yourself to other dangers.
Sure. I know we've stayed on this topic quite a bit, but allow me to say something from a dispute resolution point of view. Why it's important to sometimes look at the small print is you may be left with no avenue to resolve your dispute. Why? Because often, and I don't know whether it was a wave, you'd find that everybody is changing their dispute resolution clauses online to, guess? Clap for yourselves, come on. To arbitration. And some of those, it's not easy to access arbitration. So you feel like your data has been breached. First of all, you didn't even realize what you're signing to. You didn't even, because you're excited about getting the funds. And then you're told dispute resolution clauses, arbitration. Now you come and apply to an institute, a Nairobi Center for International Arbitration or CIAB for an arbitrator. And they appoint me, and then I charge. And you're not able to pay, and therefore not able to access dispute resolution. You understand? So the company, if it's stronger than you, it has won, because it has left you with no avenue to resolve the dispute. Thank you.
Thank you. I'm glad you've mentioned that. One of the things we are doing here at USIU as legal is we have refined our agreement, so we've dropped the arbitration requirement. We are simply going, it will be mediation, conciliation, negotiation. Arbitration is the last option in court because of the expense. And we feel that some of these disputes, because of how well we prepare our agreements, can be managed in just having a conversation, unless it's really bad and we have to end up in court. I want to ask the final one on my end. The audience will also have maybe questions on legal rights in the digital age. But this is around parents, their children, red flags to look out for with regards to children's data privacy. I'm so impressed by DPGS because we have actually a number of practitioners in that child privacy safety space, and we attend webinars where kids are actually leading the discussions on data protection. So very, very impressive. So sometimes it is the parents themselves who, violate these rules. So what should they look out for with regards to their children's data privacy? Somebody wanted to know the safeguards in place in Kenya currently to protect children from having their data privacy violated, especially online.
The Data Protection Act is really standing strong for the children. And so Section 33 just actually says you can't use children's data without consent of the parent. So in that sense, then the child is protected. But in the sense where now the parent is the one who goes out and exposes the child, unfortunately, we are not being quite fair because for us, even the children age is 18 here. At least in GDPR, they start from 13, 16. They graduate the ages of some of those consents. So what the children can do is not much, which is sad at this point, other than, because they even have the rights, maybe other than standing on the Constitution, because that overrides the act. But even then, who would go to court on their behalf? The way our laws are designed, as a minor, you really can't bring the suit in your own behalf, unless now my colleagues will tell me whether that has changed. But what, again, we are saying is, with relation to children, the general principle is you must promote the best interests of the child. Now that has been, in the child court, in the children's court, that's been discussed in many, many forums. But in data protection, it has gone down even to DNA testing. Because what was happening is parents were refusing to be subjected to DNA tests, saying they have a right to privacy. But the court has overridden that and said, but the child's best interests must be promoted. They have a right to know their father. So the father must be subjected to the DNA. That is the body of what do you call it, jurisprudence we have currently. That when you look at a child, consent is an issue. Number two, best interest. So the parent can actually be held liable from the point of, is the way you posted this child in the best interests of the child. So maybe a public interest litigation body can take up that case on behalf of that child. And hopefully we will see such legislation emerging in that field.
I want to interject there a little bit. I was watching a 60-minute news article on YouTube, and they were basically featuring, it was an investigative kind of series, and the kids in question are now of majority age. and were exposed to this kind of thing by their parents when they were minors, and the impact it had on them. So there were questions around, once I attained the age of majority, can I then sue my parents or, lodge a complaint against my parents for violating my privacy, as it were?
A very good question. Although in Kenya we don't have very rich jurisprudence around that area, in developed jurisdictions like in the EU, that is possible. And considering that our Data Privacy Act borrows heavily, almost word for word, from GDPR, that should be an available option. In terms of my reactions to your view on that, that should be an available option. It can be considered. We should be able to see how courts will interpret that. But there is a lot to learn and borrow from the European Union, for example. Now, this issue of child rights and how we can protect their, data privacy cannot be exhausted here. It's heavy, and maybe you can think of another session at a later date. However, what greatly concerns me is children who are caught in between disputes between the parents, because this is where most of the violation happens. I have an issue with my ex-wife, or I don't want to say baby mama. I have an issue with my ex-wife or with the mother of my child, hypothetically, and I want to use the child as a way of making her feel bad, or as a revenge mechanism. So what will I do? I will take photos of the child and display them everywhere online, and even details. I'll say, my child, I pay for school fees for my child in this school, but I'm not allowed to go and see my child. What am I doing to the privacy rights of my child? Again, emotions emotions tend to throw reason to the back seat, because my immediate concern is that huyu mama anafikiria yeye ni nani, that is it. And it also happens the other way around. My the mother to my child has an issue with me, and because of that she wants to parade all my details, all my information, especially if I'm a prominent person. They want to display all this information. He works for USIU. He's the director of legal services. He's a data protection officer. My number. She almost gives it to the Gen Z revolution to say hi to me. Again, what are we doing? Because now we really think about the child. And as the Swahili says, fahari wawili wanapopigana, nyasi ndio inaumia. So this is a child whose rights and interests, leave alone data privacy, even other rights, are being trampled upon like it's mere casual play, and that is where the real issue is, because James, will you take me to court because I have displayed my child on social media? Most likely, no. The best you can do is to tell me, I don't think what you are doing is the right thing. So that is where the real issue is. And I don't know, maybe we need to come together, as the thought leaders in this space, and try to think about sensitization, policy change, and many other interventions that could help us address that. Yeah.
Interjection. Now that you mentioned a child being caught in the middle of parents, I just remembered something that is currently trending. I don't know if anyone has seen Useless Thing I Got My Child. Anybody? So where now, if an ex decides to post a picture of either the mother or the father, but mostly the baby daddies, you take a photo of the child and the baby daddy, you say, this is the useless thing, I got my child, and then you expose the name. So in as much as you're being educated to know your rights, you should also know the consequences of your action. What can happen to you if you're on the other side of now, where you're the person who is breaching the data? Yeah, so it's also good to be aware of the consequences you will suffer for breaching data. Yes.
Maybe just I could chip in from a lawyer's now perspective. We call it weaponizing children. The warring parents use the child, for that particular instant, the child is just a weapon. It's like a rungu. You just take the child and hit the other parents with. Maybe we should borrow a lot from Gen Z. We need to call people out. We call them out at USIU. We call them out at my church. We call them out at my club. We do it a little bit more regularly. We do a lot of disservice to children by discussing here, and it ends here. We are all unhappy with people weaponizing children. The question is, what are we going to do about it? So I think both from the Gen Zs, call them out. Call them out. You say you don't call them baby mamas and baby daddies. They posted one, the guy is drinking Hennessy and the child is out at home today. I have a right to drink Hennessy. Patricia, tuheshimiane. So people need to be called out. What is happening is that in a country like Kenya, when we have so much problems, I didn't say about Chapo and anything, we just have a lot of problems. The one of children is put in the back seat. I think that's the mistake we are doing. We need to find a way of elevating this concern about our children, because what? We are losing a generation. And guess what? They'll have the same kind of anger issues that we think guided Gen Zs. They will remember. They will remember.
Maybe I can add one thing. Yeah? I agree with what you said, Sina. But anyway, just to, she posed a question. Can you sue your parents after you know? I think you'll be cursed. So don't try that in Africa. Not only will you be cursed, but also you'll be disinherited. So don't try that. And that is why, it's true. Your parents will die and leave property with other people. So don't try that. But I think what we need to look at is legislative and policy change. Because a lot of people are not aware. I must say that I see friends, relatives displaying little children and doing this and that. Senior spoke of sensitization, policy and legislative change. If we change the Children's Act to bring it to realities of social media age, then we can protect them at that level. Thank you.
Thank you. I think that wraps up legal rights in the digital age. I wanted to bring something up, but maybe it will come at the end. Now we move to AI in everyday life. Hey, did I hear somebody clapping over there? Clap some more. Yeah, we are so excited about AI. Can we first demystify this AI? Because people seem to think that it's a 2024, 2023 thing, but this AI, it's been there for quite a while. So can we first start by demystifying this AI? And as you demystify it, tell me why. Of course I know why, but just tell me why. Right now, if I search for, what's his name? John Mayer on my YouTube, on my phone, when I go to my iPad, it will pop up. Of course I know why, but somebody else might not know why. They might think, oh, who's watching me? So can we demystify this AI? And you will tell us how you're using it in ADR.
I don't want to play out as an expert in AI. We have our resident expert in that, and he will tell us about the technical elements of AI. But basically, what we understand about AI, especially from a data privacy standpoint, is based or anchored in machine learning, that several computer programs are able to gather and pick certain information from different quarters and package it to what you are looking for. Maybe the best I can relate with AI with my senior here is when I get a case, I've never heard about it, I don't know what to do. So I call James here, senior, I ask him, I have this kind of a case. He gives me some insights. I call Anne, she gives me some insight, and the other colleagues here. Then when I'm appearing before the client, I'm name dropping and dropping very huge names, and the client thinks that I'm very intelligent and knowledgeable. Yet I have, picked brains from my colleagues. I think that is how AI works, but I would be happy to be proven otherwise. In any event, we learn every day.
Spotlight is on me. So I want you to think about AI from the simple point of an automated decision. And now, there's what the techies will talk about AI, and then there's what the law talks about AI. A good starting point, we can start is data protection law, and then now we can probably mention what the AI Act in Europe is trying to propose. And in the process, we'll also probably touch on the American Data Protection Bill, which has a very interesting thing that I think Europe borrowed from them. So if you look at data protection laws from 2018, they have the element of automated decision-making rights. And basically what it means is that now, for those who have interacted with mobile lending apps, there's an element of credit scoring for it to decide how much you can get. That aspect of credit scoring, that's AI at work. They're looking at the value of your phone, looking at the other elements that probably you shared. We gave it permission after being notified in the privacy policy, give permission to go through your social media. So by going through your social media, based on the parameters in which it analyzes, it decides you're eligible for 10,000 shillings. So that entire decision-making process, that's AI at work. I think that's one way we can say AI manifests in this particular market, and it in a way that it affects all of us. Other places, it takes place in different ways. So this decision has been made. If it's, let's say, you're dealing with like a bank, you can, the law, the Data Protection Act allows you to now ask for a review, a human review. This was an algorithm which made a decision that has an impact on you. But now you can ask for human review. So, and what does that tell you about AI? Legally, is that there are elements in which these decision-making parameters can be biased or may be biased against you. Or it may not consider all other factors that probably a human would have if a human was in a position to make a decision about you. And that's the case, because if you look at, if we were to be very, very honest, we're in Kenya. How many AI systems are actually built here? Of course, over time, we have started building ours based on the data that we have collected, but we also don't have a lot of data on Africans, on African lifestyles. So you find that the primary or the algorithms that were created are coming from California, and based on white people and their culture and their lifestyles. So it does not factor in here that you might have chicken which has value. You might have goats which have value. So if I'm to do credit scoring, I should factor in that, a human will factor in that, but this person has been running this business, he has a border here, he has this kiosk, so he can actually raise the money. He probably doesn't have a bank account, but now if it's an algorithm that is looking at you Based on that, it will look at the formal things that it has been trained on. So there's that aspect of decision making and human appeal. The American Data Protection Bill, because they've never passed it, had an element of algorithmic impact assessment. That's similar to what we have in the Kenya Data Protection Act of Data Protection Impact Assessment. But now they stepped it further in terms of if there will be algorithms which will be deployed to this processing, we want to see the impact of these algorithms. Of course, all laws and all legislation has a motivation behind it. I'm curious to, I highly suspect it was pretty much to nab algorithm, because now everyone is developing AI systems, trying to introduce an element of accountability. And then now, we call them I'll use a shame word, the bazooks of regulation. Brussels, the EU, the European Commission, decided to now enact the AI Act. Now, the AI Act has a risk evaluation model in it. And from where I sit, I see that it goes closely to the algorithmic impact assessment that the Americans are proposing. But basically, you have an obligation to now evaluate the risks, because now if you're going to make decisions, and now we cannot run away from AI. Like, it's part of our systems. It has made business easier, and also operations to be faster, because now, if, let's say, like in insurance, there are those, you have a threshold for, let's say, claims. If it's below 10,000, just automatically approve. But imagine you have human beings to receive calls and to read emails and to approve, which will take time. But if you have a system to make the decision. So in short, the world is moving towards now an element of asking itself, acknowledging that AI is efficient and it is good, but let us have some sense of accountability in how it's being used. Let us be open to having humans review these decisions that it made, and then also let us look at the risks and ask ourselves whether we want to accept these risks and how we're going to mitigate them.
For me, I think AI, like the internet, is a wonderful byproduct of accidents. That's how most of the things to do with the internet, if you read the history of the internet, it's just more wonderful things that they stumbled upon and they didn't really know that's what they were looking for. So AI, I think, became a thing from once the .com era came. From, maybe we can start saying, around 2000s, early 2000s is when the discussions became possible. And what it was is, now, now, initially the internet was only for academia, for military and all. .com meant it's now available for commercial use. When you hear commercial use, no, it's all about profits. How can I maximize my profits? So you want to maximize your profits through efficiencies. You want to create efficiencies in your business. You do it with technology. But how do you do it? You do it by understanding your customer. So if you remember in the 1990s, understanding your customer was a very theoretical exercise. You called a marketing research firm, they went out, they did surveys, people filled, and you still were not sure what is your customer saying. But now what the Americans realized is, because they own all the technology anyway, they now have this data. So they can analyze and come up with patterns. People of this age tend to do this at this time. They will spend X amount on insurance, they'll spend X amount in school fees, and so on and so forth. So the whole idea around AI is, how do I build a product for this person to suit exactly his tastes and preferences? Then they used people who I have no idea, how their brains work, that is mathematician, to come up with algorithms, come up with a way to create an algorithm that targets the customer specifically to the right precision and offers them products that they will buy. So it was very exciting in the beginning because you're given what you want. You didn't even know you want it, but the way it's positioned, this is what I want for sure. I need this fridge, and I need it today. Because it has actually seen my problems. How many times I'm calling a fundi to come and fix my fridge at home, or how many times I'm watching a certain show. So it knows I need that kind of thing. So the intersection between AI and privacy is just how far can you go? Because you've automated everything, how far can you go into knowing who I am? And that's the battle between the EU and the US. The US says, let's not regulate AI, because if we do that, we'll stifle innovation. Because for them, let's just allow the thing to produce as much results as it can and give us the right products, give us superpower. For the Europeans, it's all about privacy. Yeah. So if you ask me what we should be doing, even what he's talking about, the impact assessment, I don't think it will ever be fair, because the person who can really show the impact assessment is the techie who develops the AI solution, and it is not in his best interest to show me the real impact that his technology has on my privacy. So for me, I feel we are entering a new era. It's no longer about whether I gave you my data. It's now about just how far are who owns what about me? What does China know about me? What does the US know? And how, for me, does it affect my life? So many people are saying, if I'm getting what I need to get, what's the big deal? The Americans asked, we don't care about China owning TikTok. As long as I'm able to do my TikTok videos here, let TikTok continue. So now it has become, in my opinion, it will be one of the hardest things to regulate. Yeah.
So, you've actually just jumped straight into regulation. It was one of the questions that had been put forward. And I just wanted to read out something that I came across as I was doing research, for this clinic. It appears that across the US, AI governance is evolving. And when I read this, I'll go back to what the two of you have said. Is evolving through a patchwork of state laws, executive actions. We are all familiar with Trump and his executive orders, and industry initiatives. So it goes further to say that the debate over AI regulation continues to intensify, balancing innovation with the need for accountability. For legal and compliance professionals, understanding these trends isn't optional. It's essential. So they go further to say more about the shifting AI regulatory landscape in the US. And you have both talked about algorithms, okay? And they are saying that while federal AI regulation remains uncertain, states are stepping in with their own legislative efforts. In 2024, nearly 700 AI-related bills were introduced across 45 states, with about 113 enacted into law. This trend continues in 2025 with hundreds of bills under consideration. And when we compare that with Kenya, we can't even make any comparison. Have we even started? There was something about an AI policy, yeah. So they go further to talk about what California has done. And California has an AI Transparency Act, which requires, this goes back to what he was talking about, which requires large generative AI providers to disclose when content has been generated or modified by AI. This law mandates the use of AI detection tools and clear labeling of AI-generated content, aiming to empower consumers to identify synthetic media. But now I want to go to something very interesting. Deepfakes. Tennessee's Elvis Act, appropriately named Elvis Act, has passed the Elvis Act, which aims to curb unauthorized AI-generated likenesses of individuals, signaling growing concerns around deepfakes and digital identity protection. And I'll go back to that when I'm talking to the litigators in this room. Colorado's AI Act focuses on preventing algorithmic discrimination in consequential decisions made by high-risk AI systems, particularly in areas like employment, housing, finance, education, and healthcare. So, deepfakes. We saw that a lot during the US election. There were these videos generated of, both camps were doing it. The Biden camp, the Trump camp. I think we saw something like that also here recently when we had the, was it the Gen Z revolution? Namsinisalimie, please. Yeah, so how is this playing out in practice? Lawyers, are we encountering this on a day-to-day? Can somebody appear in court and pretend to be Lumalas or James, or even your client? You might be there, and this would happen mostly if you're doing virtual, I suppose, because if it's face-to-face, I'm here. It's me, it's not my twin. How is this playing out in everyday life as you litigate or as you advise? There's a CS here. How sure are you that that director talking from the other side of the screen is Patricia?
I can comment briefly. Having been a victim of identity theft myself, I remember I had traveled to the US in 2014. And when I came a day after, there was a funeral for a friend. So we were going to Embu or Meru, I don't know, one of those. And on the way, I suddenly realized I can't access my email on my phone. I can't access my Twitter. I can't access Facebook. I'm told to log in, to put in a new password, and I'm completely locked out. So I'm the imposter in my own life. I also just suddenly saw money being withdrawn in my account. I saw 3 withdrawals. So I called the bank to block the withdrawals. And I realized that somebody has taken my identity. I think I knew exactly where it happened, at a counter when I was paying in the US. And then I had to report to the bank. They did an investigation, and they realized there's a ring. Someone from Cyprus, I don't know, another one from Kenya, and someone else. You know, so there's a ring of individuals that do identity theft, and they get a copy of your ID if you're checking into a hotel and all that. So it was a very, very scary experience to realize you're not yourself. You know, it happened to me. By the way, you actually are not yourself. You cannot access even your Twitter. You're told this is for Eunice, and you're not the one. Yeah. So basically, the good thing is that, for example, for banks, they actually take the liability and they refund it. So that's the fluidity in the law is works for the clients, because that was refunded. But other than that, I don't know what your experiences are with that.
So did you have to open a new Facebook account? Or
I had to get in touch with Facebook, get in touch with Twitter, and try and get myself back. Yeah.
It's become, actually here we are like in terms of legal cases, we haven't seen any, but in the US they have started to come up, and how they are dealing with it is through consent. That if I see my image likeness and it is a deep fake, I can actually go to the company that has released it and lay a privacy violation claim on the basis that it is the use of my image without my consent. So that now is progressively growing, and that's easy to do. But it's also spilling over to intellectual property rights, because especially around artists, a lot of work is being published of what artists have done. And so now again, because the US has very strong IP laws, they are able to, we are having good decisions around, you cannot use somebody's literary or work or IP work without it being an infringement of the IP law and frameworks. So that's where I see the legal fraternity moving, because the challenge with regulating technology is it's always been, what exactly is it are we regulating? Yeah, it's so amorphous. So the way they have designed, if you look at technology laws, they're designed to be what you call technology neutral. So it doesn't matter how far we advance with the technology, the principles remain the same. So we will use the same principles for data protection, for example, to then come back and say, was there transparency when you were doing this, when you were collecting my information? Did you get consent? So did you have a lawful basis? So it doesn't matter what the technology was doing. At the end of the day, the same principles should apply to reduce those incidences.
Thanks. What I'm finding problematic in our approach to AI as a country is that we want to, first of all, the country is heavily overregulated. And we want to regulate AI and be able to regulate innovation. Those two things cannot operate in the same, cannot be on the same page. Secondly, to be very frank, AI may not be a policy priority for the country right now, because we are still fighting vaccination of cows and shisha, you know. That is what is probably giving our top leaders sleepless nights for now, all right? Secondly, as a legal practitioner and even as a data privacy practitioner, I do not believe that we can regulate each and every aspect of life, especially innovation, because innovation happens in most cases outside regulation, all right? And even the business people in here will tell you that business opportunities and some of the groundbreaking business opportunities are somewhere around the gray area. And the best example is Safaricom. Safaricom was born at a time when there was no regulation to speak about that kind of a business structure and a business model. So what that then brings me to in summary is that if we are focusing on regulating AI and innovation, we are likely to miss the bus. All right? But if our policy direction is getting adequate and appropriate safeguards, and saying you may proceed with AI, you may do your machine learning and all those innovations. However, there are areas that you cannot touch. And if you are to touch these kind of areas, these are the safeguards and the controls that we are putting as a country. Otherwise, we must let our people, and the innovators and people who are building AI models and algorithms to do their thing within, some reasonable space that allows accountability and reasonability in doing what they are required to do.
Jinsi hapa kuna kitu ya kusema on AI.
niko na maoni moja. To associate myself with my senior over there, maybe it's not totally a bad thing, AI. All this time when the conversation was going round, I was just thinking, do you think when you're out of office and then automatically, just the email that goes automatically, Helen is out of office, what? So maybe I needed to reach Helen urgently. She usually replies back very, very fast. But then because she's not there, AI will tell me. So then I reach you on phone and get guidance to communicate as fast. That's the good side. So now the bad part, which I don't know how it can be regulated, but maybe just people to avoid abuse, is promoting laziness. You tell someone to write something, they go on ChatGPT, they don't even humanize it, they don't check to see what ChatGPT is saying, because AI sometimes is not very, very what am I trying to say? But it's not human. So even if you use it, don't abuse it. Yeah, that's all.
Yeah, that's the cost, maybe, Ellen, just to pick up from where Cynthia said. I made a lot of money last weekend, but I've spent it. So there is a proposed organization that is supposed to be coming up, and there's a lot of resistance from all quarters. So my services were enlisted on Sunday, this last Sunday, to try to help a petition that has been put in place. And I took it as a very good instruction. When you instruct a lawyer on a Sunday, the charging rate is not very Sunday friendly, a very, very different charge rate. So the introduction, the objection was human. And then the next 16 pages was AI. I spent the whole afternoon trying to cross-check. By the time I discovered it was AI, I'd almost grown gray hair. It can be very, very costly, as Cynthia said, to be lazy and just try to rely on AI, and especially I think in Kenya. And I think maybe the data collection is not sensitive to the value that a chicken it's attributed to a chicken in Western Kenya is very, very different value at the cost. So AI is not getting it right. AI is abusing chicken in Western Kenya. So those are a bit some lazy element of AI. But I think maybe we need to accept that it's not going anywhere. I think AI is here to stay. We just try to find out how do we make it safe. And safe is wide, including, of course, what we are discussing today, privacy rights. Thank you.
Just to add a point on that, on the laziness part, there was a recent judgment by a judge in the US. The whole judgment was by AI. So imagine sitting down, going to the library, you do your submissions, you do your research, you're like a team of 10, and this judge just uses AI. Does not even read your submission. So.
Thank you very much. We are on commercial break. No, we are not on commercial break. There are two areas that I want to pick one or two questions from the audience. 1 or 2 questions? That is very nice. All right, so we will pick one here, and we pick another one there, then we pick another one here. Those are 3. I said 2, eh? Yeah, but please make them brief so that they fit within the 2 questions. Thank you. So we start here.
Thank you for that presentation. It's really insightful. My name is Queen Kivuva. I'm from the University of Nairobi School of Law, but I'm also the Vice President at Data Privacy and Governance Student Association. I'm very glad to be here. Now, my question is, what perhaps are the safeguards that could be introduced into Article 24 with respect to privacy, and especially non-violation of asylum seekers? I'm saying this with cognizance of the overwhelming concerns we've had of asylum seekers that have come into this country but have been abducted, especially in cosmopolitan areas, for the very simple fact that someone took a photo of them and disclosed that they were in this location, and people came na Subaru wakawabeba wakawarudisha kule mali walitoroka. So what constitutional safeguards could be implemented to safeguard against, I think international law calls it rendition? Yes? Thank you.
Thank you. I hope you are taking note. Thank you very much. We are here on the second one.
Thank you. My name is Grace Wanjeri. I'm a student at the University of Nairobi and also a member of the Data PGSA. I have so many things to say, so I'll say 2 points. One, on the matter of children, I think we have to change our culture as a whole, because even if we still enact policies to like compel parents to follow data protection rules, if the culture we have that children are an extension of us, not individual people, still continues, it won't make a difference, because you'll be like, mbona unaniambia venye nitalea mtoto wangu, you get? Yeah, so that's, I thought it's more of a culture thing, so it should work hand in hand with our policies. My question now, while understanding the responsibilities that data subjects have to maintain their rights, and also the legal measures that corporations take to protect themselves, don't you think that now, okay, on the sphere of social media, because that's my interest, that such platforms should make their policies easier to understand? Because TikTok is really accused of having its privacy rules. Like, before you tick the box, I consent, if you try reading that document, it's like, I don't know, 13 pages. It's very hard to understand, even for a person who's trying to comprehend the rules they are consenting to. So don't you think that such companies should take measures to make it understandable to the users themselves? Thank you.
Sorry. Good morning, everyone. My name is Leila Kameru. I'm a student here at USIU, and it's amazing to see all these wakilis in one place. And I've always had this one question that I have 2 questions, but this one, let me start with this one. Who owns the rights on something created by AI, let's say ChatGPT, if I'm the one who created the prompt? Because I'm the one who went on ChatGPT and said that I want this and that, so don't I own those rights because I'm the creator? And my second one is on whistleblowers, because you spoke about NDAs. There's someone who spoke about NDAs. What if I sign the NDA, but then I decide that I want to go and whistleblow on something that happened in the organization? Am I protected? So yeah, thank you.
Hi everyone. My name is Jacqueline Lidande. I'm staff here at USIU. I head the partnership division. My question on the company devices is, I think there was a case on WhatsApp where I think an employee was fired because there was some things on WhatsApp that the company was able to pull. Majority of us have company devices, so I'm just like, I'm chatting with my family and all these other things. I just need to know if IT is looking into my other chats, you know, with my significant other, or are they just making sure that we are staying into the chat of the organization? Because I've always wondered about that, because I will need to know if, so I need to remove that WhatsApp from that, and also the fact that we also use like our phone. So I've always wondered, are they, I know obviously they're looking, but what are those parameters of them looking into our personal stuff?
I will come back here. I said 3. We have now gotten to...
Can we answer that first?
Yes.
Before we move to the second limb?
The second limb.
Because the questions are likely to be forgotten.
Okay.
Yeah.
I am guided.
Unfortunately, we don't have AI.
Please proceed. Sorry, I have taken over. Yes, so please proceed. Thank you.
Yeah, so I'll just want to pick 2 questions. One is on whistleblower, and the other one is, to what extent can an employer snoop into your privacy? All right? Let me start with the whistleblowers and the kind of protection that they have. Number 1, it's a governance requirement around the world that every progressive organization has a whistleblowers policy and safeguards to ensure that people can report issues that they are identifying in the organization, and that their privacy, their security is safeguarded, all right? So maybe what the organization needs to confirm is its whistleblowers policy, how well is it aligned with the Whistleblowers Act in Kenya. And the next thing is that let it be whistleblower centered, that even people will have confidence in reporting things, because you are reporting things that you believe are important and probably you don't want to be identified. Unfortunately, many organizations, but I know USIU is not one of them, say that these things are in confidence and nobody will ever know that you did. So I was once working with an organization. There was a survey, and I did not want to do that survey. Okay? So I'm called by someone who says, Anthony, you are the only person who has not submitted your survey. And I asked myself, I thought it was confidential. How do you know that I am the one who has not submitted? So then the guy starts playing diplomacy. There are two people who have not done that, and I'm calling everybody and telling them that they have not submitted. Well, I said to myself, I may have been born at night, but not last night, So that's it. And organizations, actually from a governance standpoint, I'm also a certified public secretary, and we help boards, to put up those things together. Finally, on what is the extent that an organization can go into checking my private conversations. The starting point is, as an employee, the farthest an organization should go is on matters touching on the organization. All right? Not matters touching on my private life as an employee. Remember, my contract is for the employment and the services that I provide, not other things that I do. But if my personal life is flowing into my work life, then the employer may be entitled. And the word is may be entitled. All right? For that particular case, it's a school, and it's about a procurement manager who was asking suppliers to see them behind the tent before they could be granted tenders and work to do. So in such circumstances, the organization was justified, all right, to go over and above what is normally acceptable to be able to investigate, and that person was found to be culpable. My free advice to you, at least today, is Wakili quick one, so I will not bill you. As much as possible, separate the device that you use for work from your personal device. Hiyo sio law, hiyo sio sheria, hiyo ni ujanja ya mtaa huku. Separate your the device that you use for work from the device that you use for personal reasons. Because should an incident arise and the school is investigating, or your employer is investigating, or even the DCI is investigating, they will review everything and anything in that device, including your conversations with your significant other. Yes, they will review that, because that is part of the investigation that they are going through. In any event, simu ikichukuliwa na DCI, Patricia, will you be there to tell them this one is yangu, hii ni ya rafiki yangu wa US? So that is it. Even as we expect the organization to put in place safeguards, hata wewe jikinge kidogo. Yes, thank you.
Yes, just to add, though, that now the data commissioner came up with a different perspective on that. So the Scan Group CEO, when he was under investigation, his WhatsApp chat was actually subjected to that investigation, and the data commissioner said that was excessive and should not have happened. So again, that is now going to be an evolving area, but his advice stands. Separate the two things from, if you have an office device, in fact, the office policy should have a monitoring clause that if you are using our devices, we can monitor. Because you have to do transparency. Again, you cannot just start monitoring without transparency. But the right thing is, as an employee, protect yourself. Don't have your WhatsApp installed there. Because again, now we have two conflicting decisions. In one place, they're saying we can do it. In the High Court, I think that was the High Court. And this other one in the Data Commissioner, it was said that was excessive. And he was given 1.9 million for that infraction. So you have to be careful on both ends. On the question around simplifying of policies, that is in the Act. The Data Protection Act says you should make your policies as simple as possible. Now, TikTok operates from China. So when you see their policies looking like that, they're probably following what their law of the land says when they do some of these policies. That's why they are being fined. They have faced several fines within the EU because of their practices. But currently, Workplace, the other case was for Standard Chartered Bank, where there was a monitoring of a phone call. Same case, procurement, I think. A phone call made by an undercover guy, but on the office line. And you know how it says this call will be recorded. So it was recorded and used against him in an investigation. And now there the ODPC said the bank was right, because in their policy they had disclosed that these are our devices and we are entitled to monitor them, even for purposes of whistleblowing and for purposes of investigations. So for you as an employee, as you're doing these things, please, if you're doing them with the aim of committing a crime, you can't run under data protection. The Act will disown you.
I will comment on AI creations and copyright. So far, where jurisprudence has gotten to us to is the United States Copyright Office stated that AI works are public domain, so you cannot claim that it's yours because of the requirement that copyrighted works need to have a human creator. So it's still developing the jurisprudence, because I think there's also a similar decision in the UK Court of Appeal, where now it was I think a patent filing, and the people who were trying to register were saying that AI contributed, and the court also held that AI cannot be attributed as a creator. So far, I don't think Kekobo has pronounced itself on anything. Kekobo is the Kenya Copyright Board, and so concerning that, AI works, anything that you do, and as much as you prompted, it's public domain. However, there have been discussions and conversations on whether now you take that, whatever has been generated, and then you sit down with it and develop it further, whether you can now claim copyright. But like in Kenya now, copyright has to be registered. Whether it has been filed and accepted or denied, I'm not so sure yet.
Maybe just to comment, even as you want to obtain AI-generated data, and I think I agree with that. I don't think I agree with the position that, it's not yours, it's not your creation, it's a machine. However, some of you may have followed some decisions from the US where this lawyer, I think it was well publicized, he was using ChatGPT and whatnot to prepare his submissions, and Chat generated all manner of fake precedents and cases. So ChatGPT has I think it became so big-headed. It generates fake facts and some fake case law. It makes them up. And the guy I even was asking it, are you sure this is a real case? And chat would say, yes, it's a real case. So we need to be careful. They are not humans and they cannot replace us, at least not yet. And I know, never. Yeah, so you use them wisely. I think as a client, if I have an advocate and there's another firm, I'll be more comfortable if probably the one who uses AI is maybe clients would start paying more because you see that they are more efficient and because they are here to help us to be more efficient and all that. So I think we have to learn more to use that. In terms of the case for data, for the data commissioner, I think maybe the company just didn't want to pursue it further because I am quite sure the High Court would have overturned that. Yeah, because the High Court supervises the commissioner. Yeah.
Yes. Let me just take two that were pending, then I return it. But, no one has answered your question.
So maybe I can pick that quickly. It's about Article 24 of the Constitution, absolute rights and how rights may be and how rights may be limited. Yes. Now, there already is legislation on how asylum is sought in the country and how asylum seekers are to be treated. And most probably your question is in relation to the recent of our arrest and deportation of our neighbor in the beloved country called Uganda. Now, in terms of privacy, so there are, and this is what I want us to always remember, there usually are an intersection of many other legislations and considerations. And when I was a student at law school, two category of individuals do not usually lead to the best jurisprudence and progress. One is celebrities. Number two is politicians. Cases involving politicians and politics and celebrities sometimes do not yield to very progressive or meaningful jurisprudence. In most cases, in that scenario, you know, the consideration that carried the day was the political consideration. And not that we are justifying that, all right? But then what we are saying is that these are some of the wrongs that are outrightly in violation of even the Constitution or even existing law and even international codes, you know? But they still happen, not because we do not have good laws, because we have a political system, and don't quote me, don't clap for me, because we have a political system that does not respect the rule of law very much. Yes. All right? So what you are saying is already there, because an asylum seeker is already protected by the Constitution, is already, and that may not have been an asylum per se, you know, just a citizen of another country. So in terms of, then I do not see quite the need to amend or our Constitution to say that it is ineffective or it inadequately protects asylum seekers. To me, it appears more of authorities and governments that respect the rule of law. That's how it comes out to me. I don't know if my colleagues, any of my colleagues could be having a contrary view. Yeah.
Not a contrary. Oh, sorry.
Before you pitch in, the case in point was last week there was a South Sudanese official kidnapped again from Kilimani. So it's a recurrent thing, and I think law has to. Sorry. So case in point was a South Sudanese citizen who was kidnapped last week in Kilimani again. So there's a general feeling that the law should now begin to catch up, to respect, and again, not in negation to the lack of political goodwill that we have seen and is rather apparent, but there's a very real sense in which the law is now vacuous, to not recognize even the kind of political tensions we have, such that other non-law abiding political states or subjects begin to abuse the kind of vacuum that we have. So to what extent do we then come to mitigate this lacuna that is already available to us? Yes.
Maybe.
Interesting, because I still might wish to disagree with you. I don't think there's a lacuna. And I think the lack of political goodwill is as deliberate as it can be, okay? Because at the moment, we are going to soon be in trouble with every of our neighbors. They tried the Tanzanian. The Tanzanian, I think, did Gen Z come to our rescue? Yeah. Gen Z's got the information and also ganged up immediately, because part of it is actually violence. It's violence being visited upon a visitor. When you start getting a lot of these complaints, you start wondering, does the government think it has a monopoly on violence? And that's exactly what should not be the case. We have decided that some of these actions should be left to the government. So I think the protests could be maybe more coordinated, maybe more elaborate, maybe more consistent, because we make noise once and then we keep quiet and then they're doing it. Because I think they were Turkish. Maybe one of the worst that happened here was Turkish. Because there are some people who had ran away from Turkey when things were really, really bad. You might not feel so sorry for Besigye. Things are not very bad in Tanzania, in Uganda, as it was maybe in Turkey. And maybe Besigye was here on a private visit. He was not an asylum seeker. So there are many ways of looking at it. But I think we are letting part of even abuse of somebody's privacy, we are letting the state or the state machineries get away with it. So it would not be a question of trying to go and even amend, say, Article 24 of the Constitution. I don't know how you'll speak to your politicians. Mkiwasalimia mseme ni mimi nisema mwasalimia.
I just needed to agree. I mean, there's of all the sections of the Constitution that have wanted to be amended, and there are many, none is Section 24. So that shows that it's okay the way it is. Now the issue is, as a person who's administering a country, like you're a president, you're executive, you're basically executive, like you're the president. Imagine yourself as a president. Tell me, do you know anything about that South Sudanese fellow? Other than he was arrested? Yes, you see, that's the thing. So it's an issue of what is a national interest with respect to these specific individuals. So sometimes we don't have all the facts. And as a country, the government has a duty to take care of us and our interests. So it's a question of public policy. And who can define what public policy is in this room?
You perhaps.
Absolutely. So I'll refer you to a case by Justice Ringera, which is Christ of the Nations versus Apollo Insurance. In that case, and today is Wakili Kwikwan, sindio? In that case, Justice Ringera referred to public policy as a wild horse. Like when you get on the wild horse, you don't know what direction the horse will take you, because it's wild. Anybody here who has been on a horse riding? Surely. At Uhuru Park, you guys have not done it. Yeah, so if you're actually on a wild horse, it can take any direction. What am I saying? I'm saying public policy depends on the circumstance of the case, and the country's leadership ought to have the national interest at heart. That's it. So if you have a country that has its heartbeat on the national interest, you can't be complaining.
Okay, sorry, last one. I mentioned Article 24 because I was particular about the clause on limitation.
Yes.
Yeah, that's
absolutely, yeah.
Thank you.
So the country will limit, the executive can limit, and it ought to, for our interest. Yeah.
Okay, hi everyone. My name is Abigail, student at the University of Nairobi. I have a question regarding AI. So AI has been presented as an assistant. Even if you ask OpenAI why they brought us ChatGPT, they'll tell you it's an assistant. So we've seen cases where AI has breached privacy and all that. So my question is, can we recognize AI as a legal person to enhance accountability? Just like companies have the capacity to sue and be sued, can AI, because we still want to enhance innovation, can we recognize AI as a legal person? And then my second question is to do with social engineering. I think many, if not all of us here, have experienced a thing where someone calls you and then they tell you, I'm from your bank, you need to do this. They pretend to be someone and they emotionally manipulate you to get your personal details in order to defraud you. Do you think this is something that should be included in the Data Protection Act or in the Computer Misuse and Cybercrimes Act? Because it is coming up and there are no cases that have been reported. We need to investigate and hold these people accountable.
Thank you. One last one? No. We were just taking the two pending, then we'll return it back to the moderator. Then we'll come to the last set. So here.
Yeah, thank you for the discussion. At least during the men's conference, we know that DNA can be enforced. On a more serious note, is that what happens where, and this is a case I've seen, an individual leaves, resigns or leaves employment from one organization to another, let's say a legal unit. So this person goes to the other end, goes to their LinkedIn and says, I'm excited, I'm starting a new post as XY in this firm or in this company. Then we know that these are services, so your clients read through. And then what they do then is to reach out to you and say, hey, I see you've changed. The next time they have an assignment, they go looking for this person because services are personal. Wakili, you served me, so I'll look for you. Now, this other company has come in to say, hey, looks like this person now is taking over our clients. So where is this line in data protection? Because along the way, I know you, you know me, and I've moved. And I'm offering the same service, but now with another, and most likely a rival, because they gave me a better deal or something like that. Yeah.
Yes, thank you. And finally, this one I've been given to read. What are the probable strategies that can prevent, the campaign on gender violence for social feeds, especially LGBTQ? I don't know whether you got that. Yes. Thank you. So I'm returning the microphone back to the moderator.
Thank you, Ines. That's a popular question. It featured a great deal. At the last legal aid clinic, it was quite controversial because I had a panel of liberals and conservatives. So today I want to see, do I have the same panel? Or will the panel be more liberal? James, you look like you are conservative. So can you go first?
I'm so usual on the time. Let the conservative go first.
Iris, you're smiling.
What's really the question? What's the question?
It seemed that last time the debate was centered around we are allowing too many liberties. How can you say that, and this was mostly from the male gender, that how can you say that a gay man can be a victim? Hey, John, you actually had to come forward and look at me. That a gay man can be a victim of of sexual harassment or gender-based violence, as a straight man, I should be more scared of the gay man. So, according to these individuals, they could not wrap their heads around the fact that as a gay man, I am most likely to be attacked by my partner at home, whether, forget even about I'm gay and I'm male, I'm also female. That the rates of domestic violence or gender-based violence are higher within the LGBTQI community compared to the straights or heterosexuals. So, that we are allowing so many liberties. How can you say that there is a restaurant in Westlands that has washrooms that are, what's the word we use? Gender neutral. So if I go in, I'll be accosted by this man, and we are saying no, because the argument then was, no, actually, the gay man is more afraid of you than you should be of him, because of the perception within society, how we have, I'll use the word, like stigmatized and discriminated against people who are different from us in terms of their sexual orientation.
While people are thinking, maybe I should talk to my friend, Amos. We deal with you first. Continue thinking. I'll deal with the first question about people changing employment and letting it not be known that they have changed employment. Lawyers, we have a case that we really like quoting called Jela versus Casman Brown. Jela versus Casman Brown revolved around restraining somebody, especially in these areas of employment. Or I see some employers say, if you leave employment, you shall not work for a rival of ours within 3 kilometers, within 30 kilometers, within this county for so much period. The courts have pronounced themselves on such contracts. We shall allow people to sell their labor where they deem fit. So chances are very, very high, save for some NDA issues, that there's nothing somebody has done wrong, to announce in LinkedIn that I'm no longer at USIU, I'm now at that place that is not USIU. Okay. Yeah. So there's no problem. Let them announce. So now, if you now want to reach me, if it's issues of procurement, for example, if I was vending legal services to USIU, and now I'm saying I'm exclusively vending these legal services from that other university, it's not very easy to penetrate those panels. It's not very easy. You'll try your luck before you get it. So the issues, I think, are a bit settled from the lawyer's side. In courts, we have kind of settled them. We do not like to restrain trade as much as that. Now, Ellen seems to think I'm conservative. I am so liberal it hurts. I'm so liberal it hurts. That's why I wanted the conservatives to go first. But since I have a mic, homophobia in this country is, I don't know. It's just, we can't be helped yet. Maybe as my learning friend said, part of these things are culture. We might have to change our culture. Before the African and maybe Kenyan culture become non-homophobic, you need a lot of prayers. A lot of prayers. It will take time. But we have seen Gen Zs, and I'm telling you, all of you, get ready for Generation Alpha. I think they'll change this country. If any of you are parents and you have 8-year-old, 10-year-olds, you know they are real terrorists. They are real terrorists. Give them just the national ID, they'll change this country. So whether we like it or not, this country will have to change. We are seeing LGBTQ issues arising at the workplace. The cases we know of, the ones which have hit the court, am I male, am I female, am I what, do I change my name? All those you can do. But now we are having a problem. We need to have a third washroom. I'm not sure that USIU has a third washroom. We should have male, female, and others. Okay? I'm challenging the judiciary and the government. We must have 2 jails. Somebody says if you take me to Langata women, they'll see the male version of the side of me and they'll molest me. If you take me to committee, they'll also molest me. I want my own prison. I think my own prison because I'm neither. So those issues are real. I was invited to advise on this Sexual Offences Act, and for the records, homosexuality, as at this minute, is a crime in this country. It is a crime in this country. But people have been saying there are crimes without victims. What do consenting adults do behind closed doors? Why is it any of your serious business? But still the law is that homosexuality is a crime in Kenya. Now, how are the Catholics handling this? How are the Anglicans handling this? The Anglican Church has said they'll bless same-sex unions. We are going to change the Anglican Church in Kenya. We'll say it is the independent Anglican Church. We do not entertain such. That's just an example, okay? But those days are coming. How are we going to deal with it? For somebody who is ultra-conservative, come liberal like me, I'm just saying, like Uhuru said, Uhuru Kenyatta, when he had his friend Barack Obama was coming to Kenya, he told Barack, that is not an issue to be discussed. He said that is not an issue. Barack was told, talk about Kogelo and everything else, but don't talk about homosexuality and such like that. Now, for the issue of GBV, because of my liberal approach, I have some gay friends, both lesbians and on the guy's side, they're some of the most tender people I know. Very, very polite. A lot of drama is from us who call ourselves straights. I almost rest my case, but let me just half rest it for now.
Yeah, okay. I can comment now. Because yesterday, I'm also a member of FIDA, and I've done a number of public interest litigation matters for FIDA, some of which are very gruesome GBV matters. And yesterday we saw what happened. This young girl who was a refugee, I don't know if you've seen that. She was taken from the refugee camp, given by her parents. She's a 17-year-old girl, given to a 51-year-old man. She resisted him, but they ended up beating her up, killing her and burning her. Why? Because she doesn't want to be married or to engage in that activity. Unfortunately, there is a rise of those kind of cases, mostly against women. Now, am I saying that means there are not many such GBV-related matters in homosexual relations? Probably there are many, okay? But if they don't speak up and don't speak out, then we can't know. I'm sure there are many more women and other people dealing with GBV matters that are not reported. But GBV is ideally GBV. It's gender-based violence, and sexual violence is sexual violence. And it cuts across, all right? From a dispute resolution perspective, I have to add that. It's important that we learn to resolve our conflicts also more deliberately as young people especially, because we've seen very sad scenarios of young people in universities being murdered. You know, your boyfriend, hey, they are beautiful girls that have been killed. It's very sad. I'm handling one of the cases of a young girl from Thika who was also murdered. And I think sometimes we also need to learn conflict resolution. If someone is violent, how do you react? What impulses should you have to try and deflate conflict situations that can lead to violence? And it's a whole discussion, but allow me to leave it there. Yeah. But yeah, I'm a conservative, I have to admit.
To comment in summary. Just wanted to let her know it's a whole discussion that we'll have through our webinar. Before you comment, do you have something you want to say?
You've not heard my voice much. Yes, because I'm not a data protection guru. Most of the questions revolve around that. But I can mention a thing or two. Number one, on the issue of employment. The moment a lawyer leaves employment from one firm to another, and then I post that on my LinkedIn account, I wouldn't attribute that, or I wouldn't associate it with a data violation aspect. I would say the same way I will meet you tomorrow and tell you, oh Helen, I'm no longer working for Mudogaturo, I now work for another firm. If you have worked some work for me, you can give me. It's a choice of a client to choose the lawyer they want. It's not limited. It will only bring a conflict of interest if I still work for the same firm and I get clients not attributing the proceeds to the firm, but to myself. But if I work for another firm, I left the other firm in a legal manner, I'm in another firm, then that is not an issue. Remember, under the Constitution, Article 4950, every person has a right to legal representation. So if I feel I have to follow Cynthia or Lydia to whichever firm they went, then it's my right. The other thing of the kind of information I hold after I leave employment, the much employers do is have an NDA. Typically, NDAs will tell you, don't share ABCD information to rivals or to any person without our consent, or even after you leave employment, they mostly put 2 years. 2 years after you leave employment, you should not share this information, or you should not work for a rival company. Interesting enough, as my senior has mentioned, court has ruled that is, or that amounts to unfair labor practices. Because if I say I'm a researcher, that is where I earn from. If I work, for example, I had this case for someone who worked for a manufacturing company that manufactures a fertilizer. So she was a researcher. After she left, she went to a rival company that manufactures fertilizer as well. So look at it in this way. This lady earns from, that is her field. So if I tell you don't work for another rival company, you have only worked for a fertilizer company. So if I tell you don't do that, then you won't earn. So that now amounts, as the court has held, amounts to unfair labor practices. So, as an employer, I couldn't agree more when my colleague from that side said, there is a much you can do. And the buck stops with you as an employer. Control the amount of information your employees handles and how they handle it. Because the moment that employee leaves, I won't stop you from working for a rival company, and definitely there is little I can do to control the amount of information you deliver on that side. Yes, I think, let me leave it at that. We can interact in more areas, maybe later today, but for data protection and IP, mtanisamehe.
Yeah, so what you're referring to are the non-compete clauses in agreements, and I think those have been declared unconstitutional. Yeah, I think the issue with the employee, was it the one who used to work for NCBA? That was decided, I think, yeah. This was, it was not about the client following the employee. The employee had the customer's data and contacted the customer. That was the issue, yeah. It wasn't about, oh, they moved and therefore they could not. Yeah, it was more about you contacting me after you leave Mudogagaturu, and I start wondering why you contacting me to provide legal services. I take, I take offense, and I decide I'm going to lodge a complaint with her. Of course, in the line of work you do, it is easy for you to contact me. But this was different. The employee followed this customer, the former employee followed the customer and wanted to sell to them insurance, because now they were working for an insurance company. And so the issue was, why did you allow these employees of yours to access my data even after they have left. They have it. How is this, possible? Yeah. So Cynthia, you had something to say before we close on AI, and tackle a few questions on tax. There are concerns about housing levy, fuel prices.
Yeah, my comment generally was going to be about violence. Gender-based violence, it's real, it's clear, it's there with us. As my colleague here had mentioned, mostly against women, but maybe the reason as to why we're not that aware of the violence against the people in the LGBT community is for the mere fact that this is still a crime in our jurisdiction. So then they don't come out. And even now, if you look at the culture, back in the day, as compared to right now, there was still gender-based violence against men, straight men, from women. But then they couldn't come forth because of why? The shame associated with me, wanaume, kuja niseme nimepigwa na mwanamke. So they used to hide it. So until the society or the culture is willing to accept these people with their sexual orientation, for now, they will be keeping this violence on the low. It will be happening, it will be there. But for those ones that are spoken out are the ones that we will deal with. Maybe what we can do now is just to sensitize people and to know violence against you is not okay and you should not take it. The other day we were handling a client who was burnt by the boyfriend. So, as a lawyer, we're told don't take cases personal, they're not your case, it's your client case. You go to court, after 2 or 3 sessions, the lady comes and says, nataka to withdraw. Yeah, I want to withdraw. What do? You're a lady as well, it was in the midst of femicide, women are dying left, right, and center, so how do you even separate yourself with allowing this woman to withdraw the case? And so violence is there, don't accept it. That's all.
Yes, Patricia.
Just a quick one. I'm the only psychologist possibly in here. No, there's one.
I'm also a psychologist.
There's that one. Are you sure? We'll come back. Well, I just want to, just because you're all lawyers over there, the reality is same-sex relationships are more intense in their feelings. And I like what he was saying. When feelings enter a conversation, reasoning becomes less. So if you do get a case, and it's the most unfortunate thing, because they'll only probably come and talk to a counselor or something like that. So it's something even at the workplace we need to think through. The reality of 2 lesbians in a relationship, the war between them is worse most of the time, or 2 homosexuals. And unfortunately, I think James talked about it, is the way the police ask the questions is even worse. Unachapwa na nani? Ati umechapwa na Karo. Na wewe ni Patricia. Mlikuwa mnafanya nini? You see, by the time you have that conversation, already there's no way I'm reporting. So the reality for you from a law perspective is just be aware that even at the university level, at the relationship levels, and the Gen Zs are very open-minded about this. So the intensity of that relationship is a lot worse than you would actually believe when you talk to them. So I agree with you. Violence should just be avoided at all levels. It's not my business. In fact, my position is I have no business. I don't go around saying who my sexual partner is. So what business is it, whether it's a girl or a boy, for you? As long as I've been beaten, there's a problem. Thanks.
Okay, thank you. So just before
Thank you.
we break for lunch and have a vote of thanks, this was my...
There are a couple of questions on the... So we had an issue to discuss around workplace, academic, and sexual harassment, but I think we've covered that broadly. I wanted us to talk about tax, and then it's something that's ongoing at the public lecture, gender dynamics in career progression, and specifically ageism. You can see how James is a silver fox. If you compare James to his counterpart, who is female, James basically will have more advantages compared to his female counterpart. So I just wanted us to have a broad discussion around that. And generally from, I don't want us to talk about it from a discrimination point of view, just how best should organizations ensure, because from a safeguarding perspective, that the opportunities are equal for both genders. Now I'm not talking about the other category of genders, male, female, at the workplace. Yeah, and then there was an issue about housing levy. If you could all comment perhaps on Shisha and, you know, before we wind up the morning session and, you know, break for lunch and then go to the pods where much more personalized legal advice will be dispensed. Right?
Maybe just to kick off, I know we've got the UON Faculty of Law. What are the numbers, female to male ratio of students? You're the majority, the ladies? Yes. Okay. Talking about my profession, Chief Justice, female. Deputy Chief Justice of this country, female. Registrar of the High Court, female. Judges, female. Helen, female. I think the boy child needs protection. So let's talk about it in that light.
But are we not ignoring structural realities, sorry? Systemic and structural realities. Perhaps unpack that on that level.
Okay. So thank you for that question. Yes. Yeah, only that my base is not basic. But that's a very good, line of looking at it. And one of the mistakes that we make is thinking that gender discussions are about women. Right? Yeah. That is a mistake that we do make. Now, as an organization, number one, although the 2/3 gender rule is not enforceable within private spheres, progressive organizations top from the voice from above is that they are considering gender as part of their inclusivity agenda. So from the board level, confirming or ensuring that probably to that gender rule is observed in terms of staffing, in terms of their policies and processes that are accommodative of both genders. Because I think we have agreed constitutionally there are two genders. The other thing is that, and let's not think in abstract. If today I advertise for a data protection advocate in my firm, and of the 10 applicants, 8 are from one gender, mathematically, the probability of picking from that gender is high. Okay? So that is from an arithmetic perspective. If we go to qualitative assessment, there's also a high probability that the person I will pick in terms of capabilities and their knowledge and understanding is from that gender that has a higher representation. So from a personal and the policy in the two firms that I lead, is that as much as we want to achieve gender parity, we must also ensure that we are guided by quality. Okay? If your quality, and so that's the underpinning consideration, regardless of whether it's a man or a woman. In any event, I am married to a woman, I'm the son of a woman, and my daughters are women. Right? So that is how we need to look at it, from quality, what are you bringing to the table, not necessarily your gender. Then you can decide on how to get some form of affirmative action, in quotes, right? If your office has, say, 10 employees, all right, then you need to make sure that in terms of inclusivity, you get to a level of 2/3 gender roles, at least as a bare minimum. But over and above that, you see, you can have that inclusivity in terms of the people you are hiring, but your mindset as a firm, and remember, a firm is led by the leader's thought process. Your mindset as a firm believes that the serious briefs have to be handled by a certain gender. I don't want to say men, and I'm not saying men. Has to be handled by a certain gender. And sometimes back we had a very interesting discussion about an employee who was a lady, and the boss appeared to prefer her to meet some serious investors, and her role was not necessarily, discussing and all that. Her role was to smile, like Patricia, to smile. And even the firm was dictating the kind of dress code. Yes. And I think that's a form of, discrimination and gender-based kind of violence. So it must go over and above the policies, the hiring and all that. Even the mindset and of the leaders in that firm must be such that we are providing a very conducive environment for you to thrive. Not because of your gender, but because of the quality that you are bringing on the table. Because I believe that's a clap from Lumalas. Thank you. So, and we need not think in abstract, Patricia. If in your firm you advertise for a position and only girls apply, or probably only gents apply, will you tell them all to go home and you advertise again? And that's it, because it is also said, James, unfortunately, that men are increasingly not showing up. And when they show up, they appear and sound frail and coiled. James, you want a person who can push business. You want a person who can go out there and convince clients that their ship is sinking, and unless they retain your firm, now we are just saying sorry for them. We start rehearsing goodbye songs. That's the kind of resource that you would want. But many employers are saying, the guys that we saw, hapo hakuna promise. I don't know. So let's not think in abstract. Let's also internalize on the prevailing realities on the ground. Yeah, thank you.
Just to add on that, on the gender dynamics, we can all agree that currently the girl child is more empowered to be more aggressive, you're focused on your goals career-wise, how to move up the career ladder, and you find that as the girl child is more empowered to go forward and push for their rights and push for what they want, no one is pushing the boy child to continue the same. They are still in that mindset of the man is more, if I can use the word, in charge. They're still having that mindset that I'm a man, I'll just go do this, do that, I'll get a job. But the girl child, I'll have to show myself, work towards the goal that I want to achieve. If I want to be a partner in a law firm, I have to show that I'm empowered, I push myself. And you find yourself moving up. But if you sit and say, I'm a man and this will happen, then you're left behind. And I think those are the things that are changing as we move forward.
add my voice to this debate. I've had quite a number of things being said here. I'm wondering what, because the issue was ageism. If I'm 50 or 55, it's not easy to get employed, isn't it? Because ageism is all about discrimination because of your age. And whether we like it or not, at the very, very top, men are still in charge, you know? They are still calling the shots and making the decisions. And I agree, in terms of the legal profession, whenever you go anywhere, I do a lot of moots, particularly nowadays, arbitration moots. I see many teams are just made up of women. And so I think there's an issue there which Mr. Okeo at the men's conference you can deal with. But generally, the issue here is power, influence, and money, and the men are still calling the shots at the top. I'll tell you what happens, what I have seen happening in terms of my own experience. I can't give anyone else's experience. I remember when I was a pupil, not very far from where you are now, I would do a lot of work with my former pupil master. So I would go with him to court, for example, and he would make comments like he would, speak to another advocate senior on the phone and say, and this is actually true, so and so, I can mention his name, but let me just not. Give me the name of a leading female litigant. Is there any? And then they laugh. No, I can't think of one. Then you're like, where are women, at their caliber? Where are they? Where are these top women litigants? And if you like, whether you like it or not, where you see the big cases, it's mostly men. So it's a matter of access to money, power, and influence. You still see the men. It doesn't matter how many ladies you see around. And sometimes, like my colleague has said here, even we have dealt with that issue at one point, where we have two associates, same time, they're admitted at the same time, and it's a question of, should they really earn the same? The man, at that point, is putting in more hours, he's working harder, and yet they're supposed to earn at the same pay, same level, and we are a private enterprise. Sometimes, that's why he said, at one point, you have to bring merit to the table. Unfortunately, at some point, you find women get off the scene. Even in arbitration, it's the same thing. Sometimes maybe your priorities change. Just staying on course becomes a problem. Maybe you've fallen in love with Peter and decided you want to do other things, and then by the time you come back, the men are already probably organized. So we need to look at maybe working hours, flexible arrangements. If you really want to get to a certain level, that is the truth. You have to have staying power as a girl, or as a woman. I have to say that. And also, just for the young people, I was here with Justice Jemima the other week for International Women's Day, and she said something. She said, your connections, your father or mother can introduce you to a company, you can get hired. But after that, it's your merit and your effort, So I think women have to be more strategic to get to the top.
Maybe just to interject by a brief comment, I've also experienced the same thing where, until last year I was a pupil, at KSL, the number of girls to boys were 10 to 3. Like in my group, for example, we were all girls, no single man to the group. You put in groups at Kenya School of Law for project work. So all 10 of us were girls. So I get out, I go for pupillage. We're going to court, of course, high profile case. I follow my pupil master because now you have to learn, so then you'll be following them into every courtroom. I got to the courtroom, it was just me and my co-pupil, my colleague. We were the only ladies in the room. From the judge, all the advocates in these matters were men. Now you look at them, they're from the top law firms, the big law, I call them big law. You go to their websites and profiles, you see they have leading women in those very firms, and now you just ask yourself, why weren't they sent there to come to that very case that they're handling that day? So then, maybe you were right.
people tend to talk more about women when the conversation of gender comes up, but it's because we have been in a patriarchal society where men had an advantage. So we're just trying to catch up. You might be put on something like partner track. You hire associates out of, admitted on the same time, me, a boy. We are on this track, we are being watched, work is good, let's say both qualities are okay. Approaching the dateline where now people are to be made partners, as a woman you get pregnant. Even if that same man is your husband, who goes home, who do they take? Do they take you? Do you go and leave, make your partner while you're on leave? There are those things to consider. And you will even find firms in this day and era advertising. I'm in a group where after you get admitted, you'll join there's a WhatsApp group called the by exams or something. Once you join the group, you'll see advertisements. They come out in the way of a client of mine or a partner firm of mine, a friend of mine is looking for an associate, probably 1 to 3 years, male. And they really place that on WhatsApp groups. They just say men are easy to deal with, what. And then you find others who will see it and have this conversation, like the ones who are laughing that, I can't think of any women. They say, may I only want to hire women. Why? Because they're easy to control. So they say that in this day and era. So I wanted to interject that to add to the point of why, if we talk about gender, we still tend to talk about women. We have to do twice as much. Would you 2 men or would you 2 men times 10? Yeah.
Team clap. Ageism, yeah.
This should be the last time I'm speaking now. On ageism, I have had an opportunity to work in a diverse environment. And part of a project that I did was how do we make today's workplace as inclusive, not necessarily for for gender only, but also in terms of age. For example, there is a perception in the marketplace about Gen Zs. And Gen Zs are seen in some quarters as arrogant, as disorganized, as they do not know what they are doing or what they want, and they are seen as difficult to work with. I was having a conversation with a friend of mine who is a manager somewhere, and he said that in one instance, one of his employees did not come to work. The employee was a young man, and he did not make any communication or say anything. You just report to work, the guy doesn't show up. The following day, he comes, goes to his desk, and continues working as if nothing happened. It was up to the partner to walk to him and ask, hey, I don't think I saw you yesterday at work. And the Gen Z acts surprised. Oh, yesterday, yeah, I didn't come. So what was the issue? Did you tell your supervisor? What was the issue? Oh no, I didn't tell him. So the partner wanted to understand what was the reason. And the guy tells the partner, you know, I usually see my salonist on Wednesday evening, and he was not available, so I could not come to work without my hair being done. He had some baby locks and all that. Helen, don't get mad at me. I'm just a messenger.
I'm not mad, I'm listening.
Now, you can imagine a 50-something-year-old partner and a business owner who probably has spent all his time, all his age building that business, and he's looking at this Gen Z and he's wondering, am I dreaming? You know? Now here is the complexity. This Gen Z was admitted just the other day, not even a year old. But in that farm, he does the best quality work. He's doing better than people who are admitted 5 years ago. And what came out of that conversation was the value system. For millennials and above, probably our value system is different from the younger generation. And so we were engaged in many things in that conversation, and there were different people. Some felt there's nothing to discuss. That's not an employee that you should retain. Let him go home. There were other guys who are, softy, who are saying, shika huyo kijana mkono, muonyeshe njia, nini. But that was 1 out of 5 business owners who were saying, probably what you need to do is to direct him and hold his hand and direct him to the right direction. Now, maybe you can discuss that during your lunch hour, but 2 things came out to me very, very clearly. Number 1 is our value systems may be different, but at the end of the day, kazi lazima ifanywe. And our work has to be respected. So as business owners, as business leaders, we have to think of how do we ensure that this work environment considers or is conducive both for the business and for the employees that we are having. Research has shown that in the next 25 years, more than 50% of our employees will be Gen Zs. In another 25 years, all of us here who are millennials and above, will not be working in these organizations, if we'll be alive, we'll be doing other things. So what that means then is that there must be a transition. We must hand over the baton, knowing that the person you are handing over the baton to is not like you, who can put your legs in a bucket full of cold water so that you meet client deadlines. For them, that does not appear anywhere. But still, work can be done and delivered maybe easier, more efficiently, and all that. So those are the dynamics that we are dealing with when it comes to ageism. And some of this ageism is even codified in our legislation. For example, you can only be a judge if you've practiced for more than 10 years, right? Some commissions, you have to be 5 years post-admission qualification. While it may be coming from a good place, maybe you have this level of experience, people management and interaction and all that. To some extent, it might edge out, or it might be propagating ageism. Because for you to get 10 years of experience, it means you must be probably 40 and above. What about somebody who might be maybe 2 years, 3 years, 5 years of experience, but they are equally capable to deliver in that role? Again, these are dynamics that we are living in, and I want us not to see this in abstraction. There's a lot of work that we need to do as the older generations, because now we are business owners, we are leaders in organizations, and there's also a lot of work that our younger generation needs to do for us to be able to fit in a progressive work environment. Yeah.
Anybody else want to say something?
Yeah, let me chip in something on the issue of ageism and say that change is inevitable. And so the circumstances that we are facing day in, day out. Take a case in point, a law firm setup, where traditionally we used to have those messengers, peleka hii barua farm fulani, peleka hii barua Machakos. Nowadays, service is substituted. You had like 10 messengers, wamekaa kwa farm hujawafuta like 20 years. since you started your farm. Now it's time we are doing email for service. And now as a business person, you ask yourself as a partner, do I really need these 20 people? And then you ask yourself, do any of them even know how to operate and to serve through emails? I'm speaking about the negative impact of now ageism. Now you will end up declaring their positions redundant. You see? And as a business person, you will go for one of the mechanisms organizations use while declaring redundancy, the ones we say FIFO. First in, first out. So that now you exclude 20 employees, you hire one Gen Z who is very sharp at emails to do your service. So I think some things, unfortunately, you find also, I had one encounter of an old man, not an old man entirely, I think 60 is not old. So I asked him, why did you retire? He retired. Told me now, things have changed. At my position, they had someone who was 30 years younger than me to supervise me. He's like my son. He'll be giving me commands. I can't take that. So, Kenya nimepata hiyo miaka, let me just move. So, unfortunately, I'm trying to say some instances are inevitable. So I think it's upon us, know what you do when you get there. Some issues, someone told me, some issues are not even legal. They do not require legal solutions, right? Thank you.
Just to give comfort to the silver foxes in the house, and you, because you'll get here, were we here when we had, her name is Kiwano? Patricia, speak in the morning? Were we here? Because, by the way, one day I didn't even realize I can be 5 years in practice. I was like, oh my God, 5 years, all that. You look at an advertisement, qualification 10 years, I'm like, that's unfair. Now I'm not speaking. Listen, we are in the age and we should actually be in the business of staying young. Okay? Seriously. And this is not to threaten you, young people, like you're saying, hey, here, young people are coming to supervise us. I've decided, and I'm encouraging all of you here, we must be in the business of staying young. If you listen to what Patricia was telling you, she is forever. And why am I saying that? She's diverse. And she keeps learning and challenging herself. Now she was talking about a PhD at Warwick University. I have a friend who is a QS and a teacher. I went to lecture in his class once at Nairobi University. From QS, he was 55, he went to law school. He's graduated, he's now an advocate. Remember, he's an arbitrator. We are both arbitrators. So he has one of the busiest law firms in town. Why? Because he's an arbitrator, so he's taking all those construction-related work, and that's where the money is in arbitration mostly, and energy, whatever. So he has that work. He's a lawyer, so he's in-house. He can also, and, you keep diversifying and getting young and learning experiences. You don't just sit in 20 years because you don't know how to use you are a messenger. You have to challenge yourself to move with the times. Like right now, we all have to go and learn AI as lawyers and get the technology. I told you about my partner here who is also a counselor, among other things. So basically, we are in that business, and you're not going to get us out.
I also want to add, to actually support what she's saying, and that is why Trump has written the order abolishing DEI. He's saying, let's do it on merit. Doesn't matter, you're black, you're gay, but now they had created was a system, just because you're black, you will get it. Then I don't need to do anything exceptional. It's just because I was born black, I will get this position. And yes, we understand the historical injustices, but what he's saying now, the society has progressed to the point of let people do things on merit. And then from there, we see, because how do we reward someone who who only knew how to deliver letters for 30 years. By now, he should have started an errand service business. He should have understood how errands run, and he's progressed, and he has moved beyond that. And I also support that as we grow older, because now we are in those ages where we are now even, ageism is now our thing, I support that organizations should look for policies that actually encourage those that reach certain ages to move into the next season. Keeping them till 60 is a disservice, because at 60 they feel like they're being told to go home and prepare for death. But if by 40 the conversations begin around what else you can be doing beyond, how your skills can now go to the next level, then we are having a society where then those people will be relevant. Because organizations need the 50-year-olds to come back as executive coaches to support these business people to grow into their roles. You don't need a Gen Z coaching a Gen Z. Those older generations, there's a space for them, but because of the way we have structured the workplace and the benefit, the benefits of staying for long, it's very hard for somebody to leave when they don't see there's actually more value for you out there. There's more of a market for you out there than there is in here. So for me, I think for ageism is how is your corporate policy supporting positive decision to transition? It's not a dark thing for you to retire. It's actually a great thing for you to be out there and come back and, give back to your organizations.
I'll be controversial because I'm in an institution of higher education. And I think, was it a week or so ago, there was an uproar at the University of Nairobi. Was it USIU that was raising issues about why they want to change the retirement age for teaching staff? It seems to me that in higher education particularly, the focus or emphasis is on the older you are, the more we like you or need you, especially if you are an academic. And the academics who are here or employees who work in higher ed can attest to that. So we will do what we can to make sure that you have a longer working life, to the point where you are almost collapsing in the lecture hall. But because we are saying that we need more professors, so we need more people with PhDs. To, of course, the disadvantage of those who are not teaching staff. So I think while we are formulating these policies, we have to, I want to give an example as I talk about this, that the first time I went to the US, I was very perturbed when I saw old air hostesses. I was like, what is this? Because here in Kenya, we are used to, it's the youngins, slim, and there's a certain profile they have. But upon even landing, you go to a supermarket or a mall, and the person serving you is like 60, like the age your mother or father reached, and you're like, mommy has retired, or daddy has retired, but they're still working. And there is something to that, that I'm not now dependent on my children, or, like I'm destitute, I don't know how to live. But there's also like a disadvantage to it because of perhaps, the diseases that come with the old age. And so it's, I think, a conversation we continue to have, because we saw that in the government, when they started bringing back the ones who were considering like old geezers were back, there was something that they bring. I think we all bring something to the table, whether I'm 20, 30, 50, 60, there is a value I bring. I don't want to use the word maturity because I have seen there are people who are in their 30s who are more mature than people who are in their 50s and 60s. So back to that thing we talked about earlier, the value system, how we are socialized, all those things come into play. But I agree that as we formulate these policies, let's also not do it in a manner that appears to be discriminatory. Yeah. Okay. Can we close on that juncture? I don't think we'll be able to do shisha. Do you really want to know about shisha? We'll do it in the pods, okay? So we have had very lively conversations. Now all my former pupils are here. I want them to stand and greet you all. You know, it's so exciting to see this old mama with all these small children there. Can you stand up, my babies? Come forward, my babies. Come forward, my babies. Where is Yvonne? You are still a baby. Oh, even Rachel came. So you can all introduce yourselves and let people know what you're doing now after flying high from USIU.
Hi everyone, my name is Yvonne Mwendi. I'm currently the Data Protection Officer at Airtel.
Hi everyone, my name is Rachel and I work as an associate at a law firm in Thika. It's called Ngwili and Company Advocates.
Hi everybody, Juvenalis Nyachio. I'm a partner, Matthew and Partners Advocates, Lavington. Thank you.
Hi everyone, my name is Eric Maragwa. I'm a corporate commercial lawyer at Equity Bank.
Hi everyone, I'm Josephine Otara, pupil last year, so I'm waiting to be admitted.
Is this Sophie, Effie? You are part of this team. You have like a group photo here. Yes. Okay. When we started the workshops, it was Yvonne, Juvenalis, Jeffrey is not here, and Eric. Yeah. Good. Yeah, you come and stand here.
So Helen, maybe as you take the photo,
Yes.
two of your ukunyuma.
Oh, okay.
Two of your pupils have been my colleagues.
Oh, really?
Yes, Juvenalis was my colleague. Oh, yeah, he was my senior. He was my senior, and Eric was also my colleague. And I think, yes, and also senior. But I think you really taught them very well. They've been very solid resources.
So you can take our group photo as we stand here because there will be no other opportunity once we break and go for lunch. You want to crowd around your mom? Thank you. We have to move. Switch. So, thank you. We'll be able to say thank you in a much more elaborate manner, ambassador style, USIU style. So I will hand over to, where did Ines go? Oh yes, I'll hand over to Ines. I had someone who was to do a vote of thanks, but I don't know where she is. That's Queen. Queen, you broke a cardinal rule. Do you have everything? Yes. Okay. You know everyone that you will acknowledge, or some of them, Ines will have to do it. So you can come forward and do your
vote of thanks. This is the president, vice president of the Data, Privacy and Governance Students Association. I tagged them on LinkedIn when I was advertising this workshop after USIU had publicized it, and she reached out to me on LinkedIn asking, how do we support or participate as the Data, Privacy and Governance Students Association? So thank you for bringing your team.
Yeah.
Now join me.
To move this for you here? No.
And allow me also to acknowledge my colleagues from the Data, Privacy and Governance Society. I just sent out word. There was an overwhelming response, but the vibe was with the three of you, so thank you so much for partner with us. You have your respective, two of you have your respective law firm. I know he works with Old Mutual. So during the pause, you have an opportunity to introduce your firms and see what you do. And you may have a couple of clients here in this review. And of course, to Mudoga Gaturu, Eunice, yeah, we did it. And there's opportunity to do more. So we'll be reaching out. You guys are like, you know, like your university. So okay. You can proceed.
As a disclaimer, I hate to be the woman between you and your lunch, but all protocol observed, allow me to adopt that protocol. Distinguished guests, esteemed panelists, members of our audience, good afternoon. Good afternoon once again. It is my greatest esteem and privilege to stand before you to address you. Sorry. No, it's okay. It is my greatest esteem and privilege to stand before you. I want to extend our heartfelt and deepest appreciation for making this legal aid clinic a resounding success. We have been a testament to the power of legal knowledge and empowerment in this room. We have been a testament to the great capacity for collaboration and cohesion. We have been a testament to the wonderful and phenomenal ideas that have been passed on through here. For that, and for making this event a resounding success, I want to pass on my greatest appreciation to our chief guest in absentia. I would really have loved to appear before you. I think I crammed that before I got to the bar. I had that one in mind, so I think I'll go back to my learning friends with a broken heart kidogo, but I thank you for this opportunity to stand before you in spirit. I would also like to acknowledge our astute panelists from Mudoga Gaturu Advocates, from LAK Advocates, and from our parent society, Data Protection and Governance Society. We are really humbled to be before you, but we also want to acknowledge the expertise, the commitment, and the empowerment that has been exemplified today. We want to acknowledge especially the discussions surrounding many of these phenomenal issues that are cross-cutting issues on, although we have not mentioned SHA, which was very critical to our heart, but we've also discussed on matters pertaining to employment, the gender gap, most especially ageism, and many of these conversations that are critical to us. We thank you for that. We thank you for the discussions on intellectual property, AI most especially. Many of us are budding experts who go, we are experts in growing. So we thank you for that. But most especially, we would want to thank the organizing committee and University, USIU-Africa University, who took the time to offer this opportunity to us. We thank you for your dedication, we thank you for your generosity, and we thank you for the guidance that has been exemplified. We have carried true to the vision of legal aid, so we thank you for ensuring, again, access to justice for all of us all. We thank you most especially to our audience, to all faculty members, and to the guests. We thank you again to the panelists for the engagement and for the thoughtful questions and the enthusiasm. You have been a driving force towards the success of this event, and for that we cannot emphasize enough. As we conclude, I would urge you to carry forward all the conversations that we've had and to carry this movement forward. What can I say? Tribeless, partyless, lakini hapa tuko aje? Allegiance is to the privacy movement. So hapa tuko partyless. Yes. We're moving toward that frontier, but we'd like to thank you most especially and to offer it back to you.
Tumpige makofi. That is very nice. When I grow up, I would want to speak like Gen Zs. Asante sana. So we need to give some presents. We are keeping the panelists there intentionally. You know, we are streaming this live. We feel nice when we take this photo. And let's give them a round of applause. They look very nice. You know, asante sana. So we want to gift. We want to gift the panelist. So allow me to get this off again. Can I get? I've told the gents to help me. Yes. Now you see, now this is where gentleman is coming. You know, asante sana. Asante sana. They are labeled, eh? Okay. So that just to ensure that they go to the right people, I would want to have Peter. This is a gift for? Yes, but Patricia, you want to gift? Yes. This is Peter Kimochu. A round of applause. Asante sana. Patricia, kwa mali hiyo kamera imeshika kabisa. That is very nice. That is very nice. Asante sana. So you should stay there, Patricia. Asante sana. Yes. This is James. I am deliberately picking the gems. Yes. Pande yengine, Patricia, this is yours. Yes. Asante sana. Patricia, one more for you. That is for Francis. A round of applause. Piga makofi. Asante sana. You got it? Patricia, asante. Thank you very much. Yes. Thank you very much. Can I have our Director of Finance to present the next award? Asante sana. Pigi makofi, Director akikuja. And our Director of Finance will gift Anthony. Asante sana. Anthony is coming. Yeah, asante sana. Our Director will equally gift Lumalas. Hey, I'm dressed in regalia, Asante sana, tumeshukuru. Asante sana. One more, Anne. That is for Anne. Let's give Anne a round of applause. Asante sana. Yes. They were going with seniorities. Can I get Yvonne to give the next? These are Director Legal Children. A round of applause. She said she's a big child. This is for. Hey, I just want to ensure that I pronounce it. No, it is how it is written. Cynthia, karibu. Asante sana. Where do you want? Is the camera okay? Asante sana. Thank you. A round of applause. Asante sana. Tumeshukuru sana. And Finally, allow me to invite our Director Legal to do the gifting, to gift our University Council, that is Patricia Kiwanuka. Karibu sana. There? Yeah, come. This is, it is labeled, we are getting, yeah, for Asante sana. That is for Patricia. Asante sana. So get me the gift that you've not gotten. Can I get a group photo of this panel? This panel. There? It's checking. Can I get a group photo? Can we be Asante sana? And Patricia, you can join. Asante sana. Yeah, that is very nice. That is very nice, yes. The camera people, are you capturing that very nicely? That is nice. And keep standing. Can I get the Deputy President join? The Deputy President join. Can I get our Director of Finance join? Karibu, asante sana. We want to build this one until we ensure we have one nice group photo, and it should be trending. It should be trending. Asante sana. Don't go. Can we get the children of law? The children of law. Hi, hapa. The real children of law. Hapa. But we are building this. We are getting this. And can we get the former children? Now we are building this. Tafadhali, can we get staff, faculty? No, we want to capture it nicely. Yes. Hapo tu.
Who's live?
Can you get that? And partners, can we get partners? Partners can join? Santa? Okay. It is coming. The picture is coming. The MC is coming. Wait. That is fine. Where do you want the one group photo? Okay, can I request we are having one group photo there, out, and then let me just mention that we are heading for lunch. Lunch is ready. The next side, and you do not want to miss the one-on-one section. That is where now you get in depth, you get the details. Asante sana. So we are heading to deck. Effie?
Sophie and Effie to acknowledge our partners because we forgot some. She forgot some when she was doing the acknowledgement.
Yes.